Royal Commission is now in session. Please be seated.
Yes, Mr. Gregory.
Yes.
We've got Mr. Tudge back. The appearance is the same. You now have a junior, do you, Mr. Solomon?
Notwithstanding my assistance that I needed to turn the microphone on, I failed to.
Well, that's what the junior's for.
You can rest assured I'll let him know. With Mr. Jeffries, I appeared this morning.
Thank you. Mr. Moses, you're here for Mr. Porter, I think. So.
Yes, if it pleases the Commission, I'm here with my learned friend Mr. Perry for Mr. Porter.
Thank you.
Please, the Commission.
Right. And all as usual for you, Ms. Hogan-Doran?
It is as usual. Thank you, Commissioner.
Right. Thank you.
Commissioner, my apologies for the slight delay. That was my fault this morning. Mr. Tudge, to conclude the topic yesterday, I take it you gave no standing direction to the department to investigate matters where there was a suggestion of a suicide associated with the receipt of letters under the scheme.
No.
You would appreciate, of course, that a standing direction like that had the advantage of identifying potential systemic issues as opposed to issues which might be discrete or personal to the recipient.
Just repeat that question again.
A standing direction like that would ensure that investigations had the capacity to identify systemic issues in matters where there was a suggestion of a suicide associated with the receipt of letters, in addition to the matters personal to the recipient, which might be a relevant consideration.
Potentially.
Yes.
Potentially.
Having had overnight to think about it, can you now recall any reason why you would not have asked for an investigation in the matter we discussed late yesterday?
Was provided to me. There's no evidence in all of the documents that I've looked at, which is over 8,000 documents which you've provided for me, to suggest that I was given written material in relation to it. So I presume that I received a verbal briefing from my Chief of Staff. I can't recall that verbal briefing and what he said, and therefore what my response was. I do know that I requested 2 investigations for suicides in the past, one of which we discussed yesterday, and there was one, I believe previous to that, Mr. Searle. The allegation that caused distress to the individual. In this case, again, just reiterate, I don't know what I was told verbally, but from the written information that was presented, at least to Mr. Aston, upon which he was relying upon in the absence of other information, it indicated that it wasn't connected to a debt notice as such, and that may have been the reason, but I'm speculating there.
All right. As a general proposition, was it the case that the suggestion that a suicide might be related to the scheme generally was insufficient to compel an investigation into the circumstances?
Again, I'm speculating because I can't recall the conversation which I assumed that I had with Mr. Aston, my Chief of Staff at the time. It was verbal communication. I don't believe that I was had any communication with the department in relation to it, which typically I would assume that I would in fact would get a written briefing in relation to
Certainly, you could have obtained whatever information you wanted from the department at your request.
I could have done, and again, I don't know what information I was provided with by my Chief of Staff at the time.
The evidence you gave yesterday about the annual report, the reference to approximately 5,000 threats of suicide, as part of the reason why this matter might not be significant to your recollection, does that suggest that ultimately the question of whether suicides were associated with the scheme or not was an insufficient reason to stop the continuation of the savings measure?
Just repeat that question again to me if you could.
The question of whether suicides were associated with the scheme was an insufficient reason, I take it, to put a pause on the measure, that is the savings measure, and review whether in fact it was causally related to suicides.
Any suggestion that there was distress caused by the scheme appeared to me to be connected with the implementation problems of the OCI, which I was very, very focused on addressing. Had a laser-like focus on addressing those problems and ensuring all of the issues which we went through yesterday and more which we didn't touch on, and including the fact that a compliance officer would be placed back into the role to check before any debt issues were raised. So my belief at that time, my belief at that time was that that was the cause for the distress and that those were the issues which I felt as if we had addressed reasonably well.
And did you then assume that any suggestion of suicide associated with the scheme thereafter was not a sufficient reason to conduct a further review of the scheme generally or the particular circumstances?
I don't recall any other suicide being brought to my attention where there was even a suggestion that it was at all, there was a suggestion at all that there was a connection to any welfare compliance measure, other than the one that you have brought to my attention and that I've indicated would have received, I presume, a verbal briefing from my Chief of Staff.
But one would be enough, wouldn't it? It's a budget savings measure, Mr. Tudge. One suggestion of suicide associated with the scheme would be enough.
And I appreciate the way you're connecting the budget savings as the issue in your questions. As I gave evidence yesterday, the budget savings were a component and overall welfare integrity was an important element of it as well. Any suicide is tragic. We never know what ultimately causes someone to take their life. Sadly, it occurs too often in Australia, and it's been was a big focus of our government.
You didn't hear the name Kath Madgwick or anything about her?
I recall that name, Kath Madgwick. I can't recall the details, but I do recall that name.
Okay, that didn't spark any anxiety or make you think there might be an issue to be reviewed?
You would have to remind me of the details of that case because I can't.
It was a mother who'd lost her son, and it's not entirely clear that it was Robodebt, but it was possible that it was. Doesn't ring any bells?
What period of time was that?
I don't know. Can you assist with that at all?
I don't.
It may have been after the minister's
After Mr.
time.
Tudge, all right.
Yes,
Right.
2019, I think.
Okay.
That was well.
Will be a
after my
question for subsequent ministers, I expect. But in any event, Mr. Tudge, you would have been informed, rather than speculating about potential causes, if an investigation had been directed to be undertaken by the department.
Again, I'm speculating about the fact that my chief of staff informed me. As I said, I assume he did. He was a diligent chief of staff. But I don't know what he said to me. The information available which was presented to him indicated that the connection was the receipt of a discrepancy letter, not the receipt of a debt notice. And at that stage, Mr. Gregory, certainly we had gone to great efforts to ensure the clarity of those discrepancy letters and to ensure that it very clearly stated in those discrepancy letters that this is not a debt letter. And I don't have a copy in front of me, but my strong recollection was that I wanted precisely to ensure that those letters were clearly stated that this is not a debt letter. There may be an explanation for the discrepancy, and there's a 1-800 contact number if you'd like to speak to someone about it. And that was the information which at least appeared in the evidence we saw yesterday to Mr. Aston, and upon which, in the absence of other information provided to Mr. Aston, would have been the only basis upon which he could verbally brief me. And I can't recall...
You're speculating there. You don't know what contact he had with the department beyond that email?
Well, I did ask yesterday, because it says in the email that he wanted a further briefing by the end of day, and you suggested to me yesterday, Mr. Gregory, that there was no further documentation at least available following up from that request.
Yes, but you don't know what contact he had with the department apart
No, I
from
don't.
the email.
No, I don't. That's true.
One distinction between the circumstance of Mr. Causo's suicide, in which you did order an investigation of the department, and this particular matter where you did not, was that Mr. Causo's matter had hit. Well, if you can't recall something, it plainly can't answer my question, can it?
No, but it's important in terms of, because your suggestion in the question is that I only had requested a formal investigation. I don't think it had hit the media. My recollection is that I was encouraged to do so in that instance by Jenny Macklin, who had an interest, I think, knew the family and was a constituent of hers when she was a Member of Parliament, and I had a lot of respect for Jenny Macklin and took that on board.
That suggests that it was a consideration external to the circumstances in which it occurred, which propelled that investigation.
Yeah, my point is...
Equivalent to something being in the media, more circumstances external to the point. You responded when there was an issue to be dealt with beyond the particular circumstances of the suicide.
I suppose the point I was trying to get at it was that the implication of your question was that I only did it because of the media.
That is the direct question I'm putting.
Yes, and I'm suggesting that the evidence would show that I in fact did investigations in the absence of media as well, which would prove to be contrary to the point that you're putting to me.
Well, you appreciated in the circumstance where Ms. Macklin raised an issue with you, if you didn't do an investigation, it was likely to hit the media?
No. In fact, I recall having a discussion with Ms. Macklin about it, that she didn't want to make an issue out of it. She was genuinely trying to get to the bottom of it. And as I said, I had a good relationship with Ms. Macklin. I'd worked with her previously, even before being a Member of Parliament. And we went about that investigation.
again, you accept it was an external prompt which caused you to take an investigation role in that circumstance?
In that instance, I do accept that it was a prompt by Ms Macklin. That's my recollection, and I think it's an accurate recollection.
But did you have to be asked to do an investigation, or did it have to be in the media?
It depends on the circumstances, Mr Gregory.
How do you identify those circumstances where you, in fact, conduct an investigation?
The investigation of Mr Kazau, if that's pronouncing his name correctly, was done by the department, a separate group of people, though, to the people who did the compliance officers. It appears, no, I'll just leave it there.
Right. At paragraph 88 of your statement, you say the broad rollout of the OCI began in late September of 2016, with larger numbers of letters being sent to recipients starting in early October. And you insert a footnote there, footnote 33, which refers to document CTH.400.0069.8100. There is a document similar to, I think, or at least a reproduction of the document which you footnote behind tab 82 in the bundle. It is exhibit 2010. Could turn to tab 82, and if 2010 could be displayed on the screen. The date of your signature is 6 March 2016.
Yep.
And which I think is incorrect.
I think that's incorrect. I think it should be 6 March 2017.
2017, thank you. Because it is ministerial brief 17-000172. You can see that in paragraph 1 of the key points, your Chief of Staff requested an overview of the government decision points in the lead up to the commencement of OCI. And a list and a summary of briefs and documents is at attachment A. Paragraph 3 refers to a briefing the former Minister for Human Services, the Honourable Maurice Payne MP, in which options were outlined to improve compliance to the former Social Services Minister, Mr Morrison. And then the former Minister agreed to pursue employment income data matching initiative, and the summary of the 2015-16 budget social services portfolio budget submission is at attachment B. Now, on the document that you have, and we might just briefly bring it up on the screen, you can see, if we go to attachment B, page 0065, it is completely redacted. This is introducing why I'm about to tender a new document. Before we come to that, you go to the page ending 0060, which is attachment A, and you can see B15/125 at the bottom of the page there, and there is a summary of it. It is the brief referred to in paragraph 3 of the introduction. It carries over to the next page. Testing the document management staff at the moment, but you can see there that the summary identifies the brief to Minister Morrison, which outlined a number of options, including new data sources for automated data matching, increased use of employment income matching by the introduction of a new approach to reconciling information declared to the department by the customer with information from the ATO via their online account using PAYG information from the ATO from 2010 to 2013. And the last sentence says legislative change was identified in the brief and DSS were working on developing this proposal. You can see that. And I take it because this was a brief from your predecessor, it was available to you in the records held by the Minister's office.
Ooh. I don't know the answer to that question, and depends on whether it was a cabinet document as well, which I presume it would have been.
It wasn't. I take it you didn't go looking for it?
I don't know if a minister has access to former ministers' briefing materials. That's not something that I would immediately spring to mind even now, and I've held, I think, 4 or so different portfolios.
You could have asked the department for a copy.
Again, I don't know whether it was in my mind that I had access to briefing materials to former ministers.
Yes. My question is that you could have
Well,
asked the
of course
department.
I could have. Of course, I could have asked.
Yeah.
Can I please have access to that briefing material?
Because as at 6 March 2016, after your Chief of Staff requested an overview of government decision points, there was a flag here that legislative change was a consideration in respect of the origins of the OCI scheme.
Right. Sorry, you're still referring to attachment A, that
Yes.
top there? Yes.
If Exhibit 2669 could be brought up, this is the briefing in full, Mr Tudge. Had you asked for a copy of it or found out whether you could have access to a copy of it, you would have been provided with this document, the source document for the summary provided to your Chief of Staff, which provided more than the summary of the question about legislative change, but identified the full context in which it was.
Do I have that in my bundles?
No, you don't. If we can turn to, I think it's page 7 of 10 from recollection.
So that is a cabinet document. I would not have been able to access a cabinet document.
No, it's not a cabinet document.
It says cabinet at the bottom here.
It might say that, but it's not.
It's
I mean, the one we were just looking at says protected sensitive cabinet, which gave you the summary of these things, and it wasn't a cabinet document, was it, Mr Tudge?
well, if it says cabinet, it's a cabinet protected document. Sorry, I'll make a distinction there, if I may, Mr Gregory. If you're making the distinction between was it a document which goes in the to the cabinet for presentation to the cabinet, no, it is not such a document. Is it a cabinet protected document because it goes to the formulation of cabinet materials, then yes, it appears to me, looking at it here, that it is a cabinet protected document. That is the classification of that document. And when I said this would be a cabinet document, I was referring to the classification as opposed to a document which would appear to all of the cabinet ministers for their consideration.
Right.
It was a fair way back from that. It just agreed that the departments would work on new policy proposals.
I'm only referring to the classification given.
All right.
And I don't believe that I would have had access to a document which was classified as cabinet if I was a non-cabinet minister.
Sorry, it was page 10 of 17.
You know, previous cabinets that I was not connected to, that's all I'm saying, Commissioner.
This is the proposal referred to in the summary sought by your Chief of Staff about the key decision points.
Is it possible to get a hard copy of this, Mr Gregory? Thank you.
It is the page which is summarised as increased use of employment income matching by the introduction of a new approach to reconciling information declared by the department to the department by the customer with information from the ATO.
Yes.
And you can see that the third dot point and the fourth dot point indicate the changes
Yes.
which were identified in the proposal. You can see that.
I can see that.
It's also identified in the first dot point that it was a new approach to reconciling information.
This is all on page 10 that you're looking at?
Yes.
Yes, I can see that.
And just on the factual summary there that's highlighted in the passages called out, can you identify any meaningful difference between the proposal as it's described there and what you came to understand in January 2017 of the OCI process?
From both of those bullet points that you're referring to?
Yes.
If I may just take my time to read them again.
Of course.
So just, sorry, go back to the precise question, Mr. Green.
On the factual summary in the highlighted passages, Can you identify any meaningful difference between the proposal as it's described there and what you came to understand in January 2017 of the OCI process?
I can.
Yes.
This is early stage of a proposal by the looks of it before even new policy proposals are developed.
Yes, I'm interested in the difference.
The difference is, as you put to me yesterday, which is in the first two lines of the first bullet point, that the customer will be presented via their online account with the information obtained from the ATO. Now, I don't believe that was the case as we discussed yesterday.
Because it was contained in a letter under OCI.
Sorry?
How's that different, you say, to the OCI process?
From memory, and I'm going back to thinking about the initial screens of the OCI, I don't know if it did contain the ATO. You put to me yesterday, was there a comparison between what was self-declared versus what the ATO says on an average basis, which is the implication from these first two sentences. And I don't believe that was in the OCI.
Sorry, if I understand your answer correctly, what you're saying is that under OCI, the customer was provided with information obtained from the ATO, but not the amount that they declared to Centrelink.
I'm just trying to recall exactly what those screens did contain.
You gave evidence yesterday, Mr Tudge, that the discrepancy letter, the first in the process, identified ATO information, but it didn't identify the information that the person declared to Centrelink.
That's right in the letter, and here's referring to their online account. So I'm putting my mind to what that online account said rather than what the letter said, because it's precisely referring to the online account. And I don't think, as you were alluding to yesterday, that in that online account it had the rows of numbers lined up against each other.
That is, it didn't contain the information the person declared to Centrelink.
I can't recall, but I don't believe so. It certainly didn't do as you described, and that's what I'm trying to highlight in those first two sentences.
Is there any other difference that you can identify of
Well, that first sentence, I should say. I don't believe so, but you may be able to prompt me.
I'm suggesting it's in substance the same as the OCI process.
Well, in substance, that two bullet points are, and I had to read very closely and recollect our conversation yesterday to point out the difference precisely with that first sentence.
Thank you,
So
Mr.
trying to
Tudge.
be very precise.
We could go to the last dot point on the page. This is where the reference to legislative change in the summary that you were provided comes from. If you could read that closely as well.
Yes, with that.
Subject to your concern that you might not have had access to this document even if you asked for it because of its classification.
And a different portfolio.
It's your portfolio, isn't it? Department of Human Services Executive Minute, signed by the Minister for Human Services.
Sorry, this one's signed by the Minister for Social Services.
I'm looking at the wrong document. Yes, to the Minister for Human Services for information.
It's copied to the Minister for Human Services for information.
That's right, yes. Subject to the qualification about the classification and the additional qualification you say that it was merely copied to your predecessor.
Yes.
You had within your means of knowledge, as at 6 March 2017, the ability to know that DSS had at some point advised legislative change was required for what became the OCI program.
They are very big assumptions. And I didn't see...
I included them in the question.
Yes.
Is the answer then yes?
It's subject to me being able to access it. Sorry, going back to... Can I have a look at the previous document? Because you're referring to the previous document, which I was referred to, made a reference to this document.
Yes.
And the previous document...
Mr Tudge, my question doesn't have anything to do with the previous document. My question has to do with your ability to access this document. Subject to you being able to...
But I didn't access this document, is why I was wanting to refer back to the previous document.
Yes, that doesn't answer my question. Please listen to my question, Mr Tudge. Subject to your ability to access the document because of its classification or because it was copied to your predecessor.
Yes.
Two caveats you have identified. It was otherwise within your means of knowledge. Had you got the document, the DSS had advised legislative change would be needed to implement what became the OCI system.
Within my means of knowledge.
You could have got the document,
Yes,
read that,
subject to those,
would have known it.
Got the document, read it very closely and picked that point up, yes.
Yes. And given, as you say, your laser-like focus in January 2017 on the system and that this was a brief signed to you 17 February 2017, which drew your attention to the history of decision-making, one would think your laser-like focus extended to this document as well.
I'll give a couple of responses to that question, if I may.
Absolutely.
One being that my laser-like focus was very much on the matters which were within my authority, which was the implementation issues which we've discussed. The second point, though, is that even if I looked at this document...
You're referring to the February 2015 executive minute?
The executive minute, yes. Even if I... even if I was able to access this document, did access this document, read this document closely, saw the bullet point on the bottom of page... it's not numbered here, bottom of page 10 of the 17-page document. I would have noted, Mr. Gregory, that if I was reading it that closely, I would have also noted that this was very early on in the development of these proposals. So it was recommending here, and I'm examining this, that it's agreed to the development of a package of new policy proposals with the concepts outlined here to give an indication to the Minister for Social Services that this is broadly what we're thinking. The next step of the development, of course, is the development of a new policy proposal, and in that new policy proposal process is where the full legal lens gets put over it, including in having done many, a checklist which says, can't remember the precise words, but it might even say, is legislation required? And there's a checklist which says either yes or no. And that is contained in the documents which then go to the Cabinet. Before they even get into the Cabinet room, not only does that checklist have to be ticked, i.e. that the Department of Social Services would have had to assure themselves of the legality of it to make that tick, but then the Attorney General's Department also is able to provide comment and does provide comment, typically, well, always from a legal perspective, on the proposals. They don't, and they are highlighted for the Cabinet if a proposal requires legislation, because it's an important thing for the Cabinet to know as to whether or not this requires legislation, because it changes the dynamic of a proposal, particularly if you've got a difficult Senate.
You're speaking from your knowledge now or from your knowledge of Cabinet process back then, because you didn't hold a Cabinet position back then?
I didn't hold a Cabinet position back then. I can't remember the first time that I was involved in the development of Cabinet materials.
Okay.
Which you are in any case, even as a parliamentary secretary, which I was in the previous... I was for 3 years before becoming a minister. But I certainly understand that, Mr. Gregory.
All right. Again, I'm dealing with your knowledge at the time.
Yeah, but I can't distinguish, and I apologise that I can't distinguish my knowledge and my time of the Cabinet process in detail compared to what I obviously do know today.
I understand. One of the central points you made in your response was that even if you had read this closely, you would have appreciated that something appeared on your assumption to change between this point and its approval as a budget measure.
Absolutely, that it doesn't go... well, I shouldn't elaborate, I should just stop.
That's all right. If we return then to document 2010, this is the document signed by you 6 March 2017, which contains the summary of the decision points in the lead up to the commencement of OCI.
Yep. Yes.
Paragraph 3, as I read out, in the last sentence, says that the summary of the 2015-16 budget social services portfolio budget submission is attachment B, and that was the document which was on the screen, which was fully redacted. Now, to be clear, a portfolio budget submission is a document that went before Cabinet, to your understanding.
Mr Tudge?
Yes, sorry, I'm just reading this closely before I answer, if I may.
I thought it was a more general question about
sorry, the
whether a
more general
portfolio
question.
budget submission would go to Cabinet, but
The portfolio budget submission would go to Cabinet.
a portfolio budget submission is a document that would go to Cabinet.
Yes.
Is that your understanding, was the question?
Yes, sorry.
Yes.
Should have
Okay.
been more directly, Commissioner.
That is the distinction you drew earlier between the marking on a document, that is a security classification,
Yes.
and the document that actually goes to Cabinet.
Yes.
You were given an extract of the document that actually went to Cabinet. Attachment B.
Right, okay.
You see that?
Right. Yes.
It suggests you had the capacity to get the February 2015 minute, irrespective of its classification, if you were being provided with documents that actually went before Cabinet.
I just don't know the answer to that question.
All right.
It hasn't been my practice to ask for materials from other portfolios in an earlier time which were Cabinet classified.
Right. In any event, you signed this minute on 6 March 2017. Commissioner, I have copies which are unredacted because the excerpt from the portfolio budget submission is redacted in the online document.
And at some stage it's been the subject of a ruling, has it? Or
Well, the new policy proposal itself was the subject of a ruling which was permitted
so
its
it's
tender.
accepted this falls within that?
Yes, that's right. And this is an extract from the new policy proposal.
Mr Gregory, could I make it?
I have a copy for you, Commissioner.
Thank you. Do you want to make it an exhibit or?
Yes, if I could ask that it be marked Exhibit 2010A.
2010A,
Thank you. I think Mr Tudge has already received an unredacted copy of Attachment B.
Yes.
Okay, thank you.
Everybody else has got it who needs it?
Mr Gregory, I was just going to add, if I may, just in relation to that point, that in any event I signed the documents with the implication that I was oblivious to the fact, as pointed out in that table, that a previous advice said it required legislative change. It goes back to the point that I made yesterday, that I was aware by this stage that it had been through a Cabinet process, and I was aware at that stage of the NPP development and there being a checklist or at least a statement on the new policy proposal development, and that's evidenced by the NPPs that were in fact developed a year earlier in March of 2016, which was an extension of this measure where it precisely said that no legislation was required. So I knew that the measure had been through Cabinet and through that legal process. And furthermore, at that stage, I'd known that an extension of that measure had been again considered by the lawyers, with their conclusion being that no legislation was required.
Wasn't the beginning of 2017, and you can tell me if I've got my timing wrong, about the time that the expand the tax garnishee measure came unstuck because it didn't conform to the legislation?
I think that was a little bit later, if my memory serves me correctly.
Well, wasn't it in the 2015-16 MIFO? It was supposed to come into effect, I think, in January 2017, but couldn't because of AGS advice that actually it did not conform to the requirements of the garnishee provision of the Social Security Act, which might have been a hint that going through Cabinet doesn't make something legally unimpeachable.
No, that is true, but just trying to look for the document. document, which I made a note of, but I can't find it. What's the timing of that?
My recollection is it was February 2017.
So you're right, it doesn't make it unimpeachable, but it's... in my view, Commissioner, it became reasonable for me to rely upon that knowledge that it had been through that process and that I was directly advised in the NPP in March 2017 when, with that NPP being the extension of this program, that no legislation was required.
I'm not sure that I understand your reasoning processes because you were quite concerned about the content of the letters.
Yes.
And you wanted to rewrite them, I gather, and did.
And asked for them to be tested before they were sent, and then they got rewritten again. Yeah.
But wouldn't you want to know the parameters of the authority to send the letter in the first place? In other words, what under the Act enables us to send this letter? Pretty basic question.
It is, but my mind was not at the time acting as a lawyer. It was acting as an implementer of the policy, and the lawyers. Sorry, Commissioner.
No, you go.
As I indicated yesterday, a secretary in a department will not implement things if they believe it's unlawful.
Surely as a minister, you can't count on your secretary doing everything by the book all the time. It doesn't sound a very safe way to proceed.
And in this instance, it wasn't just that, though. It was a series of things which gave me which meant that I never had a doubt in relation to the legality of the scheme.
All right, well, what I was putting to you was the very starting point might have given you a question about if we're going to redevise these letters, don't we need to know what the parameters are within which they can be redevised? In other words, what can we say in these? But that doesn't seem to have crossed your mind. Is that your evidence?
That is my evidence that it never crossed my mind as to
And similarly,
what
although
the law was underpinning that. I mean, generally, in terms of when you're developing public policy, you're developing it from the perspective of what you think the right public policy is. And you might be advised that, well, you can't do that unless you change legislation, because you don't always know what the
yeah, but generally ministers aren't
details of
rewriting
legislation
letters, are they?
Sorry?
Generally, ministers aren't rewriting letters to go to the public.
No, but generally you don't have many cases in the media alleging considerable distress based on the receipt of letters.
Right.
And those letters then became important, particularly that first letter, because of the reassurance that I wanted to ensure that it didn't scare people unnecessarily by receiving a letter which they could interpret as being a debt letter. That was a very clear thing that I wanted to do, because that first letter was not a debt letter. And we did make that point very clear in the subsequent revisions which were made.
But the step back of thinking, why are we even entitled to ask them for this information, didn't, as I understand your evidence, come to mind. Yes or no, really?
No.
Okay.
No.
And then, although you knew of the capacity of averaging to produce inaccurate debt results, the question of your authority to do that didn't cross your mind either.
The question of my authority to...
When I say authority, the departmental authority to produce an average result and treat it as a debt.
No. I'd understood that that had always been used for decades, and so it had not crossed my mind that it could possibly be unlawful. And I also knew, and this was my evidence yesterday, that which extends on these other measures, on these other pieces of evidence, that is unfathomable for a department to implement something which they know is unlawful.
Okay.
And there is a huge legal team, which, particularly in social services, which is the policy authority for these schemes, to determine what is lawful and what is not.
Seems a fairly blithe approach for a minister, particularly in the light of controversy, to assume that because it's happened before for a long time, it must be fine, and somebody would have mentioned it to me if it wasn't, which is basically the basis on which you proceeded.
No, and that wasn't my evidence yesterday, Commissioner. That was one part of my evidence yesterday. And my rationale was multifaceted in terms of why it had not crossed my mind that it would be unlawful. One of the pieces of evidence, as I said, was that it had been through a cabinet process, which I know is rigorous, and which you have at least two departments, including the Attorney General's department, look over it. A further piece of evidence was that I'd received a new policy proposal in March of 2016, which was an extension of the policy, which expressly said no legislation is required. A further piece of evidence was my knowledge that no department is lawfully able to implement a policy which they know to be unlawful. A further piece of evidence on top of that was, which is subsequent to this date, but it was through the Ombudsman's report, where there was a letter from the Secretary of the Department of Social Services, and in that letter it expressly says that it was operating within the legislative framework. So it was the culmination of those pieces of information that lent me to never form a view or even question whether this scheme could be unlawful.
Just on the cabinet process, though, you don't know what actually went to cabinet, let alone whether it actually identified averaging as part of the process. Well, you didn't then, at any rate.
I know that the cabinet process has a legal lens put over it from two portfolios.
But you didn't know the subject matter over which that lens was put.
I knew that the measures had gone through cabinet, and the measures are always summarised in the publicly available budget materials. I don't know precisely the documents which went to the cabinet. I never sought to ask for those documents either, and I don't believe I would have been able to access those documents if I did ask for them. I believe I'm about to be shown an extract.
All right, but just one last thing. I'm assuming you didn't look at the description of the budget measure itself. It wouldn't be unreasonable that you wouldn't have, but I'm assuming that you didn't look at the description of the budget measure in the budget.
From 2015?
Yes, the 2015 budget measure with the description of this measure.
Inevitably, you flick through the budget papers as a Member of Parliament, but my portfolio at the time didn't have a connection. I can't remember when I was sworn in as Assistant Minister for Social Services as well as Assistant Minister for the Prime Minister, but generally I had no involvement with welfare compliance until I became Human Services Minister on the 18th of February 2016.
Okay, thank you. I've distracted you long enough. Back to Mr Gregory.
Mr Tudge, one of the assumptions on which I've been asking questions about this document you signed in March 2017 is that Mr Aston requested an overview of the government decision points in the lead up to the commencement of the online compliance intervention at your direction.
At my direction,
at your request,
I don't.
for your information.
I don't know if it was at my request or not, but
The net result of the request is an executive minute to you, which is distributed in the usual way to the Secretary, Deputy Secretary and other relevant persons, in this case Mr Hudson.
so in the recommendations here, it's in response to a request from the Prime Minister's office, actually. So that's noted in the recommendation. So the request, according to the document itself, in the recommendation is that there was a request from the Prime Minister's office for such a document, which obviously my Chief of Staff would have put in, and he would have put that in without informing me, but of course it comes back to me as the Minister.
Yes, all right. So there is the flag there in the summary of B15125 about the question of legislative change for the measure, and the extract from the portfolio budget submission is attachment B. Can you go to that, please?
Yes.
I know you read it back in March 2017 and you've referred to it in your statement. Do you need additional time to review it now?
Was this redacted? Has this only been unredacted as of today? I can't recall. I would just give me a moment, if I may, just to
If you want time, you can have time.
familiarise myself with this particular page on attachment B. I've had the opportunity to read this, Mr Gregory.
Yes, so you understand then that this was the basis of the Cabinet decision for the commencement of the online compliance intervention program.
This was the basis of the Cabinet decision. I don't know if that's the only information that went to the Cabinet. I imagine there would have been a new policy proposal as well, which would have gone to the Cabinet, because that's always attached to any new policy which is put to the Cabinet. So this is alluding to be an extract of the portfolio budget submission, which presumably would have been in the body of the Cabinet document, and there would have been new policy proposal documents which were attachments to that portfolio budget submission, and I don't have access to that NPP to fully understand what the Cabinet saw.
First paragraph is this. DHS would introduce an online approach to require customers to take a more active responsibility for meeting their obligations. Customers would be required to electronically confirm the correctness of information DHS either holds about them or has obtained from third parties.
Yep.
This acknowledgement will include a statement notifying the customer that they will be committing an offence by failing to provide accurate information. You then go down to the dot points under the introductory sentence targeting historic overpayments due to incorrect declarations. And the second, the end of the first rather, indicates that the obligation is on the customer to ensure their record is correct and will remove the significant regulatory burden for small business that is required under the current approach. And the second dot point commences, the new approach will not change how income is assessed or overpayments calculated.
Yes.
And it continues, you can see that. And when you read this, it would have been immediately apparent to you that the sentence which said that the customers would be required to electronically confirm the correctness of information, which included an acknowledgement notifying the customer that they would commit an offence by failing to provide accurate information, formed no part of the letters or the screens for OCI.
No, that did not immediately jump out to me, even just reading it now, but as you point out, I can see what you were saying.
And the extract from the DSS portfolio budget submission, which was the decision points in the lead up to the commencement of OCI, made it clear that the obligation in the concept of the recipient having to do something in response to being presented to their information would involve the commission of an offence if they didn't assert the correctness of it. You understand that?
I do read that, and I do read that.
Yes. And although you may not recall it, you would have undoubtedly known at the time, having read that, and your laser-like focus in January on all things customer-oriented and the rewriting of the letters, that there was a material difference between the implementation of OCI and what was placed before Cabinet in this extract.
I did not have this extract in front of me at the beginning of January 2017, Mr. Gregory. This is on the 6th of March 2017.
Take my question as at that date.
But my laser-like focus on this was very much for the duration of January and going into February, where most of the improvements were undertaken, where I dedicated nearly all of my time, all my waking hours, to the improvements of the system as we saw it. And at that stage, I did not have this document in front of me.
This is a document which, as you point out, has attracted the interest of the Prime Minister's office and is generated from that level within the Australian government, and you are the responsible minister. Are you seriously suggesting you did not read it closely?
My recollection, I can't recall reading the details of this document. I would have prepared thoroughly for a meeting with the Prime Minister, if indeed, and I believe I did have a meeting with, well, I didn't have a meeting in March. I had a meeting with the Prime Minister in June and February. So going back to your question, did I read this document? I presume I read this document.
And would have read it closely.
I can't say that. It's a document for noting. And I would have read it. I have signed it. You can take it that I've read it, given that I have noted the context. But it's
surely it alerted you to the fact that that fundamental question of this obligation, which was repeatedly asserted by yourself and other ministers as the basis for the scheme, was not what Cabinet considered when it implemented it. It considered a mandatory position which would lead to the creation of an offence.
Well, no, because that first, if I'm reading the first bullet points here, it actually says that the onus is, it does create the onus to be placed onto the recipient.
In the context of the need to confirm something, and if they don't, they'll commit a criminal offence. Summary offence. It's unclear.
Pardon me?
In the context of the introductory paragraph, which form no part of the scheme.
So it certainly highlights the onus going to the recipient to provide that information, and this is something that I know the Commissioner was interested in yesterday, what was presented to the Cabinet. The Cabinet certainly
this
made a
clearly
decision in relation to this.
this clearly indicates that people are going to be given a notice under the Act, which does entitle you to say you must respond to this or you will be you'll be breaching the Act. That isn't what happened.
Failing to provide accurate information. Technically, well, I could interpret that, Commissioner, as effectively you're signing the accuracy of the information which you put when responding to the request. Just like when you apply for a Centrelink benefit, my recollection is that you have to declare effectively that the income and the assets which you say you have are truthful, and that there is a consequence if you are not being truthful in that declaration. Me reading that looks as if that's what that is saying here, that if you must be truthful in your declaration of the information which you are providing.
Sure, but the letters you sent, you saw the letters. They didn't include that statement notifying the customer that they'd be committing an offence by failing to provide information. And that's because...
No, it doesn't say by failing to provide the information. Sorry, Commissioner.
Well, they don't say anything about committing an offence.
And
that's because they weren't notices
failing to
under
provide
the
the accurate information. So I'm reading that as relating to the accuracy of the information, and indeed that did appear on the screens, that when you were updating your information, there was then a button which was the declaration to say that you are declaring that this is truthful and accurate. I can't remember what the details said in relation to the consequence, but it may well have been an offence if you did not. It may well have said you'd be committing an offence if you make this declaration that it's truthful and accurate, and it is not. I would like to check that, but that's my recollection, is that that was one of the buttons on the screen after you'd entered the information to say, yes, I'm honestly declaring that this is truthful and accurate. And you may be committing an offence if it indeed you knowingly know that it is not truthful and accurate. That is my recollection, and that's my reading of this statement.
All right.
Sorry, it's your recollection now that the screens that you went through from the customer perspective in January 2017 contained what is in that document?
I know there was, as there is in most Centrelink documents, a declaration before you sign and submit something that you are signing that this is truthful and correct. And typically there would be fine print, and would be able to find a copy of the application form pretty simply. Typically there is fine print of the consequences of signing a form.
Is this an assumption or a recollection?
It's a recollection.
Your recollection is there was fine print on the OCI screens that said that they would be committing an offence if it was.
My recollection is that at all times when a person is applying and dealing with Centrelink and providing income information in order to access payments, that they must make a declaration that it is accurate. That is my recollection. I equally have a recollection that in the screens before submitting the information, you effectively were declaring the same sort of declaration, that it was accurate, truthful and accurate. I can't remember the precise details then that it says afterwards, whether it does say, this is subject to whatever provision it is, and that you may be committing an offence by knowingly declaring false information.
You can't recall the bit which relates to the offence provision?
I can't recall that, but it would not surprise me that. But I do recall there being, as I said, the declaration which you have to make, and I also recall that in nearly all declarations for Centrelink, which you have to do all the time, that there is frequently fine print which sort of says the nature of the declaration. And so my reading, Mr. Gregory, just to repeat, of that sentence which you are alluding to, goes to the accuracy of the information.
That's your reading of it?
That's my reading of it now, is that if you provide inaccurate information knowingly and deliberately, then you may be committing an offence. And I think that was always the case with Centrelink information. But that's just my recollection from 5 years ago. And
yes, that's not what the sentence plainly says, Mr. Tudge. They will be committing an offence by failing to provide accurate information. It deals with the onus.
So the previous sentence, customers would be required to electronically confirm the correctness of information, and this acknowledgement of confirming the correctness of the information will include a statement to say that they would be committing an offence by failing to provide that accurate information. So reading those two sentences together, I think it does refer to the fact that if you provide inaccurate information, you would be committing an offence.
You don't read it as a question of the obligation reinforced by an offence provision?
I don't read it as that.
Very well.
Those two sentences together, I don't think come to that conclusion.
Okay,
I think they come to the conclusion which I was articulating.
have your answer. And plainly, that was the reason why you didn't think it would be prudent to get advice about the question of the reversal of the onus.
The reversal of the onus appears more clearly, Mr. Gregory, in the first bullet point. And for all of the reasons which I had articulated, it did not cross my mind that this was unlawful.
Did you ever, when you started in this portfolio, say, can you give me a précis of the Act and how it works in relation to entitlement and payment?
Not in relation to the Act, no. I did go through, I should just answer your question, no.
Okay. Well, I can understand you would not sit down with the Social Security Act on a sunny afternoon, but you might want to understand how this actually worked when you were considering this program.
I understood the payment structure generally, so Commissioner, my knowledge was to try to understand how the overall system worked with the knowledge that, well, with the assumption that everything that was being done was, of course, lawful because you...
All right. I understand what you're saying about that. Thank you.
While you may not have turned your mind to the question of the legality of the scheme in January 2017, people within the department did.
Yes.
And I take you to tab 19 6 in your bundle. It is Exhibit 4233. Sorry.
Sorry, say that tab number.
Tab 196. On 10 January 2017, this document was prepared.
Sorry, which date?
10 January 2017.
Right.
That is, I think, within 2 days of your return.
Yep.
The day after you met with the Prime Minister to discuss the particular article in the Sydney Morning Herald that he sent you.
I don't think I met with him. I think I may have spoken to him on the phone.
All right. The day after you spoke with the Prime Minister, after he referred you to the Sydney Morning Herald article, which raised the question of the accuracy and lawfulness of averaged debts raised by the means of averaging. Now, can you explain why instructions to the Australian Government Solicitor were drafted on 10 January 2017 by the Legal Department in your department?
This is the first that I've seen of this document, Mr. Gregory, ever. It doesn't. Is this from the Department of Human Services, and who developed this document?
There were 3 lawyers who worked on the document in the legal branch of the Department of Human Services.
Yes. And
I'm asking you whether you can explain why, if you didn't turn your mind to legality in the first couple of days when you came back, your legal department would be preparing instructions to the Australian Government Solicitor about the lawfulness of averaging.
I can't explain that. The first that I'm even aware that that was occurring.
As I understand the effect of your evidence, this must have been initiated from within the department because it was not initiated by you.
It certainly was not initiated by me.
Right. And you didn't consider it prudent to obtain advice about the lawfulness of averaging at any point?
It had not crossed my mind, as I've indicated.
Just before we leave that document, can you think of any reason why draft instructions to the Australian Government Solicitor on a program affecting so many Australians would not have been progressed to final stage in seeking advice?
No.
You agree with the benefit of hindsight. It would have been prudent to obtain legal advice on these contested questions of accuracy and lawfulness.
Definitely. Even going back to 1990. And at every stage along the way in the development of the process, which used income averaging.
And I take you to tab 183, Exhibit 4731.
Yep.
The email is dated 18 January 2017.
Yes.
From Ms Dryden, and It refers to a request by Mr Aston on how much the savings forecast to be gained through OCI would have been gained if the department continued with the manual process previously undertaken. You see that?
Yes.
Was that a question that you were asking?
I don't believe so. I don't have a recollection of that.
That
This
is
was
January 2017.
January 2017, 18th of January 2017. I don't recall asking that of my Chief of Staff. I may have, but I don't recall.
Would it be unusual for your Chief of Staff to make a request for a ministerial brief or a Minister's Office information request about a matter related to the federal budget without you asking him to do so? Given the circumstances in January 2017 and your focus on the...
Yeah, in January 2017, we were asking for a lot of information, so it would not have surprised me at all that my Chief of Staff was asking for information separate to me. He was involved in each of the conversations which I was having with the department from the 9th of January when I returned.
Right, if you go to page 0279, which is the response, see the first paragraph.
Yep.
Savings recognised in the budget using automated data matching for 2016-17 was 1.2 billion.
Yes.
Undertaken manually using the process in 2015-16, the savings achieved are forecast to be approximately 150. I take it when you were provided that information, the option of going to a fully manual system was not attractive to you.
I didn't have the authority to return it to a manual system.
So I didn't ask you that. When you read that, I take it the option of going to a manual system was not attractive to you.
You're making the assumption that I received this document, which I may have. I'm not saying that I didn't, but it's not. I understood that the reason for the measures which were introduced by the Cabinet in 2015 was to undertake more compliance activities, because as even one of those previous documents which we're just discussing, Mr Gregory alluded to, that up until that time, in fact it's in that extract that we were looking at just a second ago, the current resources only allow us to review approximately 5% of the potential overpayments identified each year. So the Cabinet determined to do things in a different way in order to undertake more reviews. And this was suggesting here that should we return to the manual process completely, that you would not be able to undertake as many reviews. So it's completely contrary to the Cabinet decision.
Yes, you're answering in an objective way. I'm talking about your state of mind. The idea of returning to a manual system, which is the question asked here, and the impact on the budget, was unattractive to you because of the significant loss of revenue which was projected to flow if that decision was made.
I don't know my state of mind at the time. Sorry, let me answer it if I may. It was, I don't know if I did read this, and I don't know my state of mind at the time, assuming that I did read it. What I can say is that from that time, income averaging was paused, which was the effect of the changes which we're doing, and that had a very substantial impact on the budget for 16-17. I do know that when it was unpaused, a manual component was reintroduced, we discussed two places where a manual component could be introduced, and it was reintroduced. So my state of mind did come around to introducing the manual component. And furthermore, my state of mind came around further later that year to making decisions which had a very dramatic impact on the financial state of the budget, reducing the forward estimates from $4.2 billion to $1.9 billion on the basis of the submission which Ms Porter and I put to the Cabinet in late 2017.
That submission to Cabinet was the result of what was actually happening rather than your conscious decision to resort to a manual-based system.
No, but the implication of your question was that I was always concerned about chasing the dollars, and in fact the decisions which I was making was irrespective of the dollars which were being brought in. My focus very much was on the implementation of this scheme, and that meant that income averaging was being paused. That meant there weren't as many compliance reviews. In fact, almost no compliance reviews were done in the first half of 2017. And the implication of that was a dramatic downgrading of the financial situation, which I was aware of, and has implication for the broader budget because it was, as we discussed yesterday, a significant savings.
The decision you made was in August 2017. You might go to tab 276, Exhibit 4801. Mr. Tudge, this is the document which informed you that the process of averaging would continue following two genuine attempts, I think, to contact the person before the application of the ATO data.
Can I read the document before answering that question?
Yes.
So to answer your question, it says on paragraph 4 that not only were there two attempts to call the recipient, but as you see in paragraph 4, that before taking that step, there was evidence that the recipient is aware of the initial letter, that they had been provided at least 42 days with extensions available to respond to it, that they were reminded about the review, reminded the recipient about the review, and then further 2 telephone calls made to the recipient's telephone number.
You highlighted and ticked it twice.
I don't know if I highlighted that.
I've been the secretary or a DLO or a staffer or an advisor.
I don't know. Typically the ticks, sometimes I would do those ticks. I'd assume they were mine. And that may have been specifically in relation to D, or it could have been in relation to all 4 of those points together.
Anyway, the brief was to you for noting
Yes.
that the department was resuming the application of PAYG data after those steps in respect of initiations of discrepancies which had continued
Yes.
and resumed to normal levels, that is pre-February 2017 levels.
Yes.
Yes, it doesn't reflect your decision about anything, it's just information to you for noting, isn't it?
Yes.
Right. Returning then to the question of the interest of the Prime Minister's office, which we touched on before in respect of the decision points. You gave evidence yesterday about discussions with the Prime Minister or the Prime Minister's office. It's important that I understand very clearly what you say you told the Prime Minister or his office about the OCI scheme in the sense of any flaws that it may have had. Did you present a rosy picture, or did you tell him all of the real concerns that you had about the scheme, which obviously didn't include lawfulness and inaccuracy?
So I had a few conversations with him, but I was not in regular communication with the Prime Minister. As a Cabinet Minister, you're in regular communication with the Prime Minister, but as an outer minister, you're not. Or you don't tend to be. The first meeting I do recall with him, so the formal meetings, sorry, let me be clearer. There was 2 formal meetings that I believe I had with Prime Minister Turnbull along with Minister Porter, the Secretary of Department of Human Services. I can't remember if the Secretary of Social Services was there. And inevitably there would have been some staff present.
When was the first?
The first was in, I might say in my statements, but certainly in January or February, I think February of 2017.
Did you tell the Prime Minister?
And there would have been materials, sorry.
Yes. Did you tell him about any concerns you had in respect of the scheme?
There would have been materials presented to him, and those materials, I imagine, would have outlined some of the issues and what we've done. And I recall the Prime Minister obviously being concerned about, well, what happened? Why did this system go awry? And I remember him reflecting on the fact that there needs to be more rigorous testing before a system is rolled out. And I believe it was pointed out to him by the Secretary, if I recall correctly, that there was in fact some testing of 1,000 recipients before the OCI was rolled out. I recall him suggesting that the DTO needs to be more engaged. And at that stage, he may have also suggested that Data 69 be commissioned as well to help with better identifying the highest likelihood of people owing money.
Data 61?
Sorry, Data 61.
These sound like conclusions which were expressed by the Prime Minister after receiving information. That is, there should have been more engagement.
Yes.
The Digital Transformation Office ought to be involved. Maybe you get an external consultant in the form of Data 61 to review where you're at. Am I correct in my understanding that these were suggestions following the presentation of the information?
Yeah, I do recall this meeting. There wasn't really a presentation. I think he had the materials in his hand. I recall where he used to sit in his...
Was the material assuring him that it went off the rails, but everything was able to be okay.
I don't know. The materials may well be in one of the documents here, or they may well be in one of the 8,000 plus documents on the discovery system, which he made available to me. But I do recall the Prime Minister very quickly, and Prime Ministers are always busy, very quickly went to the point of what happened. Why did this go wrong?
And what did you tell him?
In essence, was describing the fact that there were problems with the implementation of the scheme, Commissioner.
Which ones?
So, again from memory, and maybe my memory is aided by sort of reviewing so many documents, all of the types of things which are outlined in my statement of the things which I identified early on in January 2017, I believe. And then, as I said, it very quickly moved to the way that you described it, Mr. Gregory, in terms of conclusions. That's my recollection of that meeting.
Yes, but there may be a step missing here. You say you identified issues with the scheme to the Prime Minister that are outlined in your statement.
Yes.
We know that that didn't involve any concern on your part about legality, correct?
No.
And we know that didn't involve any concern on your part about the onus being on the recipient to provide information under the scheme?
That was the Cabinet decision that I was operating within.
Yes, I'm just confirming what you did not convey to the Prime Minister. You didn't convey any concern, I take it, about the transfer of the onus.
I don't think we went through in detail how the overall system works. My recollection is we very much went into what went wrong with the implementation. That's my recollection, and the Prime Minister was guiding the questions, and very much as it wasn't. I don't think it was a lengthy meeting. It was what went wrong. Okay, I get that now. You appear to have got many of the things fixed. Here's what you should be doing in the future. You should have more testing. You should get Data 61, which is an analytical company within CSIRO, to assist with data matching, which we did. And I don't recall the other conclusions. I think they were the main two conclusions that I recall coming out of the meeting.
And just for what you did tell him, can you look at paragraph 105 of your statement and tell me if that's what you were telling him?
Let me find my...
105 of your statement, which is, it's at the beginning of the first brief, the first folder.
Do you have a page number, Commissioner?
On the screen, it would be 0020.
Oh, thank you.
That's what I was getting at, Commissioner. And I can't recall how much I got into these details, but my mind was very much on these things. And if I was explaining what went wrong, these are the type of things that I believe I would have been raising.
That's what I want to know. Thank you.
And what you also said was that the Prime Minister's response was you seem to have it fixed.
No, I don't recall him precisely saying that.
Did he say words to that effect?
No, I don't have that recollection.
Right. It's just that you said it before, that's all.
I haven't got notes of that meeting. I'm going from memory of a meeting, when was it, 5 years ago, and I've held 4 portfolios since.
Yes, as I said at the start, it's very important that you be accurate about your recollection of what you
Yes.
said, because we're relying on your recollection.
You are.
And you've told us earlier that it was a short meeting, he guided the questions, what went wrong, you seem to have it fixed, in the future you should be doing these things. Now, is it your recollection that you conveyed to him that the problems you identified with implementation were resolved?
Were well under control. I believe I would have communicated that those implementation issues were identified and that we worked very hard to resolve them. And I believe his office would have had that communicated as well, and they would have had regular communication with my office throughout December and January, and understanding what we were doing, and they would have provided a note to him before this meeting.
You were providing a degree of assurance, as I understand, to the Prime Minister
In relation to the implementation issues.
that the issues of concern identified in the media were in hand, being addressed.
The issues of concern which, not just to pick you up on that, not necessarily identified in the media, but the issues of concern which we had identified, which I had identified, were being addressed,
Right.
which weren't all raised in the media.
Was Mr Pratt the DSS secretary at that meeting?
I don't think he was, but I don't know for certain.
Thank you.
Mr Porter may have a better recollection of that.
Thanks.
Do you recall instructing Ms Campbell to engage Data 61 following the meeting?
I don't recall doing that, but I must have done that given that Data 61 was engaged.
Can I take you to tab 217? Exhibit 1796.
So that confirms it here. So that's clearly an indication here. Oh, sorry, I'll wait for your question, Mr Gregory.
Is that email the email you sent to the Secretary following the meeting with the Prime Minister, at which he suggested you engage Data 61?
That looks like it. Oh, in fact, yes. I will say yes. That appears to be the case here.
Yes.
And so
The second paragraph says we should always be seeking to improve this functionality to ensure we are targeting those most likely to have received overpayments.
yes.
This letter is, this email is uses more formal language than you generally use with Ms Campbell. Is that because it came from the Prime Minister's office and you wanted a clear record of your position?
Probably. It'd be very rare for me to suggest a particular firm. In fact, I don't think I ever suggested a particular firm to be engaged for any other piece of work. Sometimes I would suggest a consultancy be engaged to assist with something, but for probity reasons, I would always leave that up to the department as to who they would select. In this instance, I was suggesting, as that email says, Mr Gregory, very clearly Data 61. And that's because is my firm recollection, and I didn't really know Data 61, I don't believe, up until that point. It was my firm recollection that Prime Minister Turnbull wanted Data 6 or suggested that Data 61 be engaged with him knowing their function, their capability.
The sentence I read out contains the inherent acknowledgement that the scheme may not be targeting those most likely to have received overpayments.
Well, the sentence says we should always be seeking to improve the functionality. I think even today, Mr. Gregory, you could still do more and more sophisticated analysis to try to improve that functionality. And that's simply what that was saying.
Do you accept that it acknowledged that the scheme caught those who were not most likely to have received overpayments at this point in time?
At that point in time, there was a system which I accepted based on departmental briefings and advice, was designed to pick up recipients who were the most likely to have received overpayments. I didn't have reason to doubt that it was operating reasonably well, but as is indicated in this email, and as I indicate to you even today, it can always be improved because it's an analytical function. And you can always improve the analytical capability to be able to select individuals. And this is the very first step of the process, Mr. Gregory.
Did you ever see a report produced by Data 61 following their engagement?
I believe I did. I leave it there. I believe I did.
And what was the effect of that report?
My recollection is that I was underwhelmed with the report, my recollection is that the department was equally underwhelmed in terms of it didn't provide particularly clear advice as to how the system could be improved. My recollection is that they seemed to take considerable time to do the work, and then having done the work, it didn't appear to be an overly useful piece of work for the purposes of which we were seeking. That's my recollection, but I don't have the documents in front of me, but that is my recollection.
Just to be clear, could I ask if Exhibit 4759 could be brought up? CTH.3001.0051.1320. It may be behind your tab 221, Mr. Tudge. Is that the report you're referring to? There is a second document. You might want to consider that also.
I don't recognise this report. It doesn't even say Data 61 on it.
All right. Can you go to tab 226?
It's not to say that I haven't seen it, I just don't recognise it today. Sorry,
226?
226?
Do you recognise this document as the one that you saw?
Again, I appreciate this one is a Data 61 document, but
You may not recognise it, Mr Tudge. I just need to have your answer.
No, I'm just, well, it's a 36-page document and you're just putting it to me now and I'm just trying to recollect whether I do recognise it or not. I don't recognise it. Again, it doesn't mean that I didn't receive it or that I didn't flick through it amongst the thousands of documents that would have been presented to me.
Mr Tudge, do you recall in January, February 2017 that as part of the political strategy that was adopted to defend the scheme by you, there were assertions that this had been in place for a long period of time and under previous Labor governments?
That was my understanding.
Yes. One document I wish to take you to specifically is behind tab 61. It is exhibit 4668, an email from your advisor, Mr Wood, to you, copying in your Chief of Staff and Media Advisor, 7 January 2017. You were either on a plane or shortly to get on a plane. The attachment is revised talking points, DHS online compliance system, and then a PDF, Plibisec shortened 2011. You can see that.
Sorry, which?
See the attachment listed there in the header?
Oh. Yep.
All right. Just trying to clarify some factual issues and understand whether they were brought to your attention. You'll see the talking points behind tab 62. Exhibit.
The attachment, is the attachment there?
4318.
Yep.
And the talking points referred to in the third paragraph, Centrelink is simply doing what has been done for years, including under former Labor government. In fact, Bill Shorten introduced part of this data matching back in 2011, you see that. And then the second attachment is behind tab 63, Plibisec Shorten 2011, and you can see a media release Wednesday, 29 June 2011.
Yep.
Exhibit 4319.
Yes, I do see that.
You do see that? Do you recall that media release?
I recall it now.
Okay.
Only from going back through the documents.
All right. I'm suggesting to you, and we'll come to the departmental email shortly, that when you read that document, you would have appreciated it related to automation of garnishes, the automation of garnishes relating to debts which had already been established.
Sorry, whereabouts? Going back to the email?
No, if you had read the media release that's on the screen there,
oh, right.
you would have appreciated it was relating to the automation of garnishes.
Oh, tip of that press release. Yeah.
Yes. That is relating to the automation of garnishes. Yes. All right. And can I take you then to complete the point to tab 44? Exhibit 4659. This is an email the previous day, so 6 January 2017, between people within DHS in response to an inquiry from Rick Morton from The Australian, asking about the media release from 2011, and the question was, is this now precisely the same system being used at larger volumes by the government? And you can see the response at the top in bold between members of the office. Sorry, the answer under the question in bold at the top. This is not the same system. The 2011 intervention was automating the garnishing of tax returns to repay welfare debts. You see that?
No.
All right. You see good afternoon, Melissa, at the top?
Melissa, yes.
Melissa, sorry.
Doesn't seem Mr. Morton could tell the difference between data matching and debt recovery.
Right, I see that. Sorry, what was your question?
That the department's position was that the 2011 intervention was automating the garnishing of tax returns for welfare debts.
That particular intervention looks as if that's the case.
Yes, all right.
It was automation. I mean, there's been automation, as I outlined in my statement, going on since 1990 and continues to go on in all aspects of government.
You're talking about, in this particular context, the automation of data matching between the department and the ATO.
Yeah.
Yes.
And this was, I should point out though here, I'm presumably building up to something else, but I was on leave at this particular point in time and it was being provided to Ms. Porter.
Yes. Mr. Tudge, to complete matters, I indicated to you yesterday I would take you to some information about averaging that you were provided by the department very early in January, but I should do that out of fairness. You see behind tab 56, Exhibit 4663.
Yep.
An email from Melissa Golightly to you and others, including the Secretary.
Yes.
The process map to which you referred earlier in your evidence as attachments.
Yes.
And you go to tab 58, Exhibit 4665. You will see a table which contains the process map.
So that was tab
58.
That was the process map. I think I took it out yesterday.
Yes.
Yep.
And it describes the old process, the interim process, and the OCI. And as you said yesterday, the old process was pre-1 July 2015.
Yes.
All right. And step 7 in the old process informed you that
That's right.
if insufficient information was provided, the customer compliance will use ATO information and apply income equally across the period. You see that?
Yes.
Right. And that was one of the sources of information provided to you by the Deputy Secretary to assure you that averaging was being used for this scheme.
And later on it's mentioned, as I indicated to you yesterday, in the Ombudsman's report, and it was verbally always.
Yes, I'm just talking about this period of time.
Sorry, my apologies. Yep.
And the email on 7 January 2017 included attachment A, process map supporting points document. And if you go to tab 59, Exhibit 4666.
Yep.
You can see here this was a more detailed explanation.
Yes.
If I take you down to paragraph 6, which refers to the old process, C, that the request for documented employment details was obtained from either the customer or employers. All interventions, that is 100%, required documented evidence to enable the assessment, outcome calculation and raising of any identified debt. You see that?
I see that.
And if you go over the page to paragraph 9, you see documented evidence may come in various forms. Payslips which had sufficient detail to validate gross income and the period of employment, employee letter or pay report, bank statements. D is of particular relevance here, a tax assessment notice.
Yes.
And you immediately appreciate, of course, that's not a PAYG report from an employer.
Sorry, what was that question?
An assessment notice is not a PAYG report. It's the document, the assessment is the document issued by the taxation office to the employee.
Yeah, I don't know, but...
Okay. But it indicates that it's a form of evidence which only provides sufficient detail to reasonably validate gross income if the period of employment is for the full financial year. You see that?
That's what that says.
Yes. So the broad assertion that averaging was used prior to this point in time, which was first documented for you on the 6th of January, came with some qualifications about the requirement for documented evidence before the debt was raised.
Correct.
All right.
That was the nature of... that was the nature of the old process.
Yes. And what changed in the interim and new process as they are described there is that in the absence of those categories of documented evidence, a debt could be raised.
Well, a debt could be raised even under the old process in the absence of those categories.
How do you arrive at that point given the parts of the document I just took you to?
Because, I mean, I'm looking at step 7.
I see.
Which says that compliance officer will use ATO information and apply income equally across the period if insufficient information is provided. That's the step I'm looking at.
Right.
And I've since become aware that I didn't have these figures at the time, Mr. Gregory, that...
Mr. Tudge, that you know you're not answering my question now. Can I take you to tab 57? Exhibit 4664. Ms. Golightly sends an email to various persons within DHS.
Yep.
And it records your discussion at length about the methodology of averaging.
Yes.
You can see that.
I do.
And your request for a description of processes under the 3 time periods before you got on the plane.
Yep.
Now, do you say something more was said to you during that lengthy discussion than what was recorded in the documents that I just took you to, produced as a result of that conversation?
I recall having the conversation, and I recall that it was a lengthy conversation. I was calling from the UK from memory before I boarded a plane, I think. And I think that email indicates that. And it was... It was the beginning of the discussion of me trying to understand in detail the overall process, Mr. Gregory.
Yes, I understand that, and I understand the context in which you had the conversation. My question is, do you recall being told anything more than what was contained in the documents emailed to you following the conversation to which you have just been referred?
I'll say I don't recall enough specifics about the conversation.
All right. And finally, Mr. Tudge, tab 79, exhibit 4682. This is an email trail 25 January 2017. You can see that it starts on the page 0334 from your Chief of Staff to Ms Golightly, copying in an advisor and a DLO.
Yep.
It refers to a meeting that day. Two quick questions. The first is, can you confirm it's accurate to say that for many years the onus has been on the customer to provide information that explains any difference between their income reported to Centrelink and their income data held by other government agencies? The onus on the online compliance system is no different. Centrelink staff will help customers gather information and navigate the process, but the onus has been on the customer for many years. I take it you were clearing lines for the purpose of media releases or interviews?
I don't know. I wouldn't assume that from this email, because typically the Chief of Staff wouldn't be doing that if it was for a media interview. It may have been, I don't know the precise date for the meeting with the Prime Minister, it may have been in relation to that.
Right. It's clear though that the question was on your mind about how long the onus had been in the position it currently was.
Well, to be fair, it's not clear from this email, that proposition you put to me, but it may well have been on my mind.
Well, it attributes the questions to you from the meeting that day, which indicates that it's on your mind. Do you accept that?
So I'm looking at Andrew's. Right, yes. Sorry, I'd had to look all the way to the bottom where it says, where it's got Andrew Aston's, my Chief of Staff's email to Melissa, where it does say 2 quick questions from the Minister for our meeting today.
And the answer is at the top of the page. From Ms Golightly.
Yes?
Which tells you that the responsibility has always rested on Centrelink customers to provide correct information in relation to their payments.
Yes.
See that?
Yes.
Right. The last of that paragraph is the critical bit. Previously, where the customer failed to respond or was unable to provide the required information, the department would request additional information from third parties on their behalf. Centrelink customers now carry more of that responsibility.
Yes.
That clearly communicated to you that there had been a change in the onus
Yes.
for OCI.
Mm-hmm.
And so it would not be correct to say that this is the system, that OCI didn't change anything.
That was not a change of the OCI, so no, it's not. That's not correct to say that.
Was it a change under the PAYG manual compliance?
This change occurred. The change when the Centrelink officers no longer made the calls on behalf of the recipients to employers or to banks occurred from the 1st of January 2015 under the manual compliance intervention program.
That is the first stage of the Robodebt scheme established under the Strengthening the Integrity of Welfare Payments.
Well, the first stage of the scheme, which has been defined as Robodebt, yes, there was technically no such scheme called Robodebt, as you know.
In answer to your second question, just below that, when did DHS first start matching ATO PAYG data with Centrelink income for the purpose of compliance? You were informed that that first occurred in 2001 as a pilot, and funding for PAYG matching was provided in the 2003 federal budget. You see that?
See that?
Now, you've given evidence here that it went back to the early 80s. It seems you were informed quite specifically in this email that it commenced in 2001 and then more formally in 2003.
And I was relying upon the Ombudsman report, which reflects upon the information that he was provided, and it does say in one of the footnotes in the Ombudsman's report, which I'm sure I could quickly find, which does refer to the date 1981.
Right.
Would you like me to find that reference, Mr. Gregory?
I think he'll ask you if he wants you to.
Okay. Now that's all right. The difference will be obvious on the document, Mr. Tudge, if there is any.
I keep thinking you're about to wind up and not taking the morning break, but should we do that?
I've wound up. That concludes my examination.
Thank you. I do have one last question, which is of a similar nature to the ones I've been asking you about whether you considered your authority to do various things.
Yes.
This one's about the penalty, which was euphemistically referred to as the recovery fee, but in fact it's a penalty.
Yes.
You seem to have been concerned about whether it had to be charged and whether people could just say they had a reasonable excuse.
Yes.
But did you consider what authority you had to charge it in the first place, how you could charge it?
I did, and there's some evidence in the materials that I, in fact, inquired as to whether or not we had to charge it.
Okay, but that's
Not
a different
from a
question to whether you could charge it.
The answer was effectively the same, which was why I was going there.
But you see, to charge the penalty fee required that the person in question had failed to comply with an obligation under
Yes.
the Act
Yes.
to provide information, say at the time they were receiving the benefit. That's the only basis on which you could do it. But you couldn't assume that when you couldn't assume that an averaged debt
No, I was
accurate.
And I was concerned about this, and my desire was to remove it. And in practice, I was told that the legislation requires it if you don't have a reasonable excuse. And so I changed what I could do immediately, Commissioner, was to change the system such that there was an assumption that everybody had a reasonable excuse unless you openly declared that you did not. Now, in practice, that meant that no longer was there a 10% fee. Later that year, Minister Porter and I put forward a submission to the Cabinet to propose getting rid of that 10% fee through legislation.
Can I suggest that was putting the cart before the horse, because before you could even think about charging it, it had to be the case that the debt arose in whole or in part because the person had failed or refused to provide information in relation to their income or provided false or misleading information when required by a provision of the Social Security Act to give information. And my point to you is, with an average debt, you couldn't be confident that anyone had done that because you couldn't be confident that the debt was correct. But the answer I'm seeking is just, had you thought about that or not?
I had not thought about the legal basis for it, other than being told that it was a legal requirement to apply it, and hence, while that was the case, I was trying to come up with ideas to work around it.
I think that's fairly apparent from the documents that you did spend a lot of energy on that question.
Thank you.
All right, thank you. Ms Hogan-Doran.
Commissioner, I have no questions of the witness.
Is Mr Goh still with us? Mr Goh, you weren't seeking any leave to ask questions, I take it? Thank you. And so back to you, Mr Solomon.
If the Commissioner pleases, there's no re-examination. Is the Commissioner's practice to excuse the witness?
Well, I think so. I can't imagine why not.
no reason why not. Thank
If
you.
the witness could be excused.
Thanks. Thank you, Mr Tudge. You're excused, and we will finally take the morning break till 5 past.
All rise. The Commission is adjourned until 12:05. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. The next witness is the Honourable Christian Porter.
Yes. Mr Porter, will you take an oath or an affirmation?
An oath, Commissioner.
Okay, would you stay standing and the oath will be delivered?
Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thanks. Take a seat. Yes, Mr Gregory.
Thank you. Commissioner, can you tell the Commission your full name, please, Mr Porter?
Charles Christian Porter.
Mr Porter, you were served with a notice to give a statement and produce documents NTG-0035 dated 18 October 2022.
Yes.
And you produced two statements and an attachment in response, the first dated 9 December 2022 and the first dated 18 November 2022 and the second statement dated 9 December 2022, which attached a summary of media statements or media releases in respect of the scheme.
That's right, yes.
You identify in both statements some limits to your availability to access documents in the preparation of those statements. Subject to that qualification, are the contents true and correct?
That's correct, yes.
Commissioner, there has been an issue in respect of Mr Porter being able to access diary entries in respect of the period in early January 2017 in respect of meetings to which he refers without that degree of specificity in his statement. I understand that steps are being taken to identify those entries and produce them while his evidence is underway.
All right.
I thank Council Assisting for noting that issue. We've been in communication with the Commonwealth since November to seek those diary entries in respect of those critical meetings in January, especially given the significance of the questions posed by the Royal Commission. And the Royal Commission has assisted us in communications with the AGS to get documents in a timely fashion. We've asked repeatedly for the diary entries for January, which are quite critical because of a representation made by a public servant in respect of what is said to have been legal advice existing in respect of this scheme. That hasn't been forthcoming. What we were given, it was inadequate material which shows no diary entries for January. And yet, when we pressed again today, we're told we'll be given an Excel spreadsheet, but this is on the day of the hearing. And the Royal Commission made it very clear, you've been given a very tight time frame to produce a report in this matter, yet the Commonwealth that set up this Royal Commission hasn't had mechanisms in place to provide documents in a timely fashion to former ministers of the Crown to get access to these matters.
What are you asking for, Mr Moses?
So these are quite important matters, and what we've asked, again, is the redoubling of efforts by the Commonwealth to produce that material today before Mr Porter finishes his evidence so that these matters can assist the Commission and his evidence.
Right.
Thank you.
Well, I think we're all ad idem about wanting that to happen. Ms Hogan-Doran?
Commissioner, I'm instructed that amongst the material made available to those assisting Mr Porter were the series of emails sent and received comprising meeting invitations and meeting acceptances or declinations. That was part of the broader access that he was given through his solicitors to historical agency-hosted emails. What was not able to be done is to reconstruct his diary, so his diary was unable to be produced in the form in which would have been observed at the time. What has been provided today by the Commonwealth is an aid memoir which simply lists all of the material that has been produced in an Excel spreadsheet.
So are there no existing diary entries as such, are you telling me? Or?
The meeting invitations and the meeting acceptances have been produced, but they are not a reconstructed diary.
All right. What did you understand the diary to look like, Mr Moses?
Well, Royal Commissioner, firstly, no documents have been produced that relate to that January period in terms of the diary entries. Now,
okay, but when you say diary entries, what are you expecting to see? What are we talking about here?
may I ask through you, Royal Commissioner, whether Mr Porter can answer that question?
Sure.
So that I don't, as it were, miscommunicate the position.
Right. Mr Porter, what are we talking about when we're talking about diary entries for January 2017?
Well, I, like most ministers, would have worked with a Microsoft Office diary that most people would be familiar with, so you'd have days and weeks with various entries at various times. During that period, there were a range of meetings. I can't recollect exactly what dates they were on, who was at them. That's the sort of information that, in my recollection, would have been contained in that diary. I'd assume that there'd be some ability to simply access my accounts from that period of time.
Commissioner, could I just ask the witness to stop? There's no transcribing of this.
Oh, that's all we need.
Sorry, Commissioner, I'm being told there is a transcribing, it's just not a live feed to those in the room.
Okay, so the live feed's down, but it's transcribing. So anyway, we're talking about meeting details, not meeting content. Is that right?
That's right, but those details would have likely assisted in who was at meetings and so forth. And I can't recall seeing those particular emails which were sent and received about invitations, but they wouldn't necessarily provide the picture that the actual Microsoft Office diary would.
Okay. Ms Hogan-Duran, we're not that far off lunch actually, so is Mr Porter likely to see them at lunchtime?
Yes, I understand they have been provided to Office of Solicitor Assisting and they are printing out, or will take steps to print it out, so he will be able to review it. He and his solicitors will be able to review it.
All right. Well, it sounds as if you'll be able to familiarise yourself again with them over the lunch break, and then you can have access to them while you're giving evidence, so it doesn't sound too disastrous. All right,
And Commissioner, it's the nature of the archiving system. It's what's occurred with other witnesses.
All right. Thank you. Mr Gregory.
Thank you, Commissioner. Mr Porter, you took on the role of the Department of Social Services Minister from 21 September 2015.
That's right.
And you continued in that role through to December 2017.
Yes.
Thereafter appointed to the Office of Attorney General.
Yes.
Until March 2021.
Yes.
That brief chronology confirms that the Strengthening the Integrity of Welfare Payments measure introduced in the 2015-2016 May budget was underway before you were appointed to the role as Minister of DSS.
That's right.
But you came to learn of the measure and its implementation throughout 2016.
Yes.
In broad terms.
Yes.
And one of the ways in which you learned or gained some initial information about the measure and how it was being implemented in practice was through a ministerial submission, which I think you signed in April 2016, which gave you a broad overview of some information.
If I could see the ministerial submission, that might refresh, but...
Absolutely.
Yes.
I'll take you to it now. There are 4 volumes of documents there, Mr Tudge.
Yep. Porter, moving on.
Mr Porter, it's been a long 2 days. Don't be overwhelmed, it's only the first 2 which are likely to be relevant to the documents that I take you to. But Volume 1, Tab 50. Exhibit 4854.
Commissioner, could I just inform you that there is still no transcript for those in the hearing room, but I understand it's being disconnected and hopefully re-established shortly.
Okay. I'm sure if we're not actually recording, somebody will break it to me.
Sorry, Volume 1, Tab 50?
Yes. Is that a ministerial submission as appears on the video screen in front of you?
No.
It's not.
Sorry, forward a minute. Yes, I have it now.
Oh, thank you. Before I go to the content of it, Mr Porter, can you just briefly outline the way in which you were routinely informed of matters about which you made requests as the Minister?
Yes, so you would have a submission that has a face page of the form that you see on the screen. They would contain different information for different purposes. Colloquially, we would probably have called this a submission for noting, but no specific action was required, so it was meant to provide information. That's my handwriting on it. And so once you had read or considered it in whatever level of detail, my practice was to tick the noted part of it and put any instructions to my staff in my own handwriting.
And just to confirm your handwriting in the top corner, there's a circle there. I see that on other documents. Is that just a...
Yeah, just a weird affectation that I've had for a while. It just helps me break up a page and see things.
It's like a dot point.
Yes.
Thank you. And can you confirm what you have written for the record, please?
There it says, CD, can you provide me with a colour copy and email PDF CCP 060416?
And CD is?
That would have been Charlie Donovan, who was my PA at the time.
Thank you. The purpose of the document is set out under the heading Purpose, and it indicates you requested information about DHS compliance activity at a ministerial planning day on January 13 of that year as a follow-up to information to an earlier briefing. See that?
Yes.
And in response to that request, this document contains various information. The particular parts I will take you to, which just establish, it seems, the extent of your information at this point in time. Firstly, on the second page under the heading Compliance Interventions. The third dot point identifies verification interventions, which is explained there, where a document evidence is required to confirm the recipient's correct rate, and that includes reviews where the recipient is called in for face-to-face review or streamlined data matching reviews. That is, there appear to be two categories of verification interventions there, or two styles in which that might be taken.
Yes.
Again, I accept it's in broad terms, but if we go to page 3 of the document under the heading Recent Compliance Enhancements, there is a reference here specifically to the 2015-2016 budget measure, which includes streamlined data matching for PAYG earners, and it sets out the way they are presented with a statement outlining discrepancies, and it continues. Again, all this information was in very broad terms in response to your request.
That's correct, yes.
The next subheading is Compliance Activity 2015-2016, which indicates really the scale or volume of reviews and the dollar value in respect of those reviews.
Yes.
Right. Just under that heading, there is a document which is referred to as Attachment A, and that is further information on DHS compliance activity as provided in Attachment A. Now, I'm not sure if your bundle, no, I can see it doesn't have the attachment. I think a hard copy has been prepared. Commissioner, the document that's been presented to you in hard copy, could I ask that it be tendered and marked 4854A?
Yes, 4854A it is.
It's the complete document, Mr. Porter, but I'll just briefly take you to page 1 of 10 at the bottom, which I think is the 4th page in.
Just procedurally, does this mean that this attachment wasn't in the documents that I previously had the opportunity through my lawyers to view, or?
I can't tell. That is, I don't know the extent of the documents provided to you by the Commonwealth, but I can see that it has been produced from the documents provided by the Commonwealth generally. If you go to page 1 of 10, you can see that the heading is Information on Current Compliance Processes. And if you go to page 5 of 10 in the bottom corner, the heading is Strengthening the Integrity of Welfare Payments Budget Measure. And under that large heading, there are a number of subheadings. And if I take you to page 7 of 10, Mr. Porter, you will see at the bottom of the page the subheading Increased Use of Employment Income Matching.
Yes, I see that.
And again, this was the extent to which additional information was annexed to the minute in response to your question about the measure which came to be known as the Robodebt scheme.
What question did I ask about the Robodebt scheme?
No, you did. You asked, under the subheading Purpose, for information about DHS compliance activity at the Ministerial Planning Day.
Yes.
Following on from a further briefing. And I am suggesting to you that this attachment contained a range of additional information compared to the body of the submission, and the information included this paragraph here, or this subheading, which was the first information that you received about what came in time to be known as the Robodebt scheme. That is, you didn't ask a question about the Robodebt scheme, but this is the information which is relevant for the Commission's purpose, which came before you.
Yes. I mean, I can't say definitively if this is the first time that I've ever received information on it as Minister, but...
No, that's right. You may have been given some information about it prior to April 2016 as part of the 15-16 MyEFO measures, but this is in response to a request made by you, it seems, in early January 2017 for further information about a range of matters.
Yes.
And so at least by this point in time, the extent of information that you had appears to be contained in this document in the dot points which follow the subheading Increased Use of Employment Income.
Yes.
Yes. And to identify very briefly, there is the third dot point which refers to a customer or Centrelink income recipient being presented with information from the ATO via an online account, and them having the opportunity to update the information, and it continues over the page to confirm that it put the obligation on the customer to ensure the record was correct by providing evidence.
Yes.
And although the delivery of the measure was the responsibility of DHS, the information that you had about the scheme remained largely unchanged from this document until you relieved Minister Tudge later in the year, while he was on leave.
I don't know. I don't recall any further or more extensive briefings necessarily than this, although I do recall, which I think was in my written statement, that there was the issue of the budgetary cycle for MyEFO, I think, in 2016.
Yes, later in the year, which included proposals related to the expansion or extension of various measures under the strengthening.
That's correct. So to the extent that constituted additional information on the scheme, that would be an additional information that I would have received before I commenced acting for Minister Tudge.
Yes. In a general sense, is it your recollection that the information that you gained through that MyEFO process later in the year was generally described as an extension to existing measures?
Yes, with this caveat that there would have been some scrutiny at that time as part of my role in the budgetary matters associated with this program, to be assured that the projections of savings were realistic projections. And so that wouldn't have involved, and to my recollection, didn't involve any additional information about the mechanics or the operation of the system. But what it would likely have involved, although I don't specifically recall it, but from experience, it would likely have involved stress testing the concept that an escalation of X transactions to Y would result in a certain amount of revenue, noting that it's not always the case that the increase in savings is a linear relationship to the increase in volume of the activity undertaken. So it would have been a macroeconomic style of information that would have been provided additionally.
Yes, I might just take you to a document which is part of that process. It is Exhibit 4859 behind tab 55.
Yes.
You can see there the title of the document communicates the topic of savings measures under your portfolio for the 15-16 MyEFO and 16-17 budget. The body of the email attributes to you a request attaching a list of the savings measures that the Minister has taken forward in 15-16 and the 16 budget. You can see that.
Yes.
Now, at this point in time, 3 May 2016, the prospect of the federal election was approaching.
Yes.
And there were various election commitments shortly before the election in respect of savings which were able to be achieved, that is pre-election promises from this portfolio.
Yes.
And to my recollection, the approximate figure was $2 billion in savings from budget measures as a pre-election commitment.
That accords with my recollection as well.
Thank you. And if I take you to one document which was attached behind tab 61, Exhibit 4865, you can see there a colour chart which sets out various measures and projections into the future, at least as they existed as at May 2016.
Yes.
In terms of stress testing the financial aspects of the proposals, of course, that process involved the Department of Finance as well as your department and the Department of Human Services.
That's correct, yes.
As is the ordinary course in the development of new policy proposals for introduction into a budget.
Yes.
And can I take you now to tab 66? This is 28 June 2016, which I think was the date of the announcement of the measure. Exhibit 2574, sorry, the announcement of the savings as an election commitment.
Yes.
And at the bottom of the page, can I briefly identify for future reference, the email is from Ms. Cheryl William, who was, I think, your executive assistant.
Yes.
All right.
Chief of Staff. Sorry.
Chief of Staff, thank you. And the reference in the balance of the email is to the coalition election policy and includes, of course, the requirement for persons on New Start to report their fortnightly income on a fortnightly basis.
Yes.
And you understood, if not from this email, from your role as Minister, in general terms, that persons who received income support supplements were subject to a means testing and income testing process, which involved generally fortnightly satisfaction of thresholds.
Generally, yes.
Generally, yes. And if you turn to tab 67, immediately behind it, it's not necessary to bring it up, but you can see that it is the Coalition's plan for better management of the social welfare system. This is the Coalition policy release statement dated 28 June 2016, shortly before the election.
Yes.
Thank you. Continuing the chronology, can I ask you to turn to tab 69, Exhibit 5872. This, again, is an email to your Chief of Staff. The title is Briefs for Deep Dive. and there are a number of attachments. The email is initially from Mr Whitecross to Mr Pratt and Ms Wilson and Mr McBride. Firstly, Mr Pratt was the Secretary of your department.
Yes.
Ms Serena Wilson was a Deputy Secretary within whose area these issues fell.
Yes.
And Mr McBride, as you can see from the footer of the email immediately above it, was a Group Manager in respect of the Social Security branch, I think, within DSS.
I don't recall him, but
No.
that appears to be the case, yes.
Thank you. Now, the attachments are described as the agreed revised A3s. Can you confirm that that is a reference to a budget process, the A3s?
Not with certainty.
Right. In any event, the reference is to those documents which have now been sent to both PM&C, that's Prime Minister and Cabinet,
Yes.
and DHS, which is, of course, at that time, the Department of Human Services, now Services Australia.
Yes.
The date of the email is 5 August 2016, and I'm just drawing your attention to these documents for reference. The first attachment is briefing welfare reform meeting with PM August 2016. You can see that?
Yes.
And then a few lines down, there is another attachment described status of legislation input for deep dive.
Yes.
Right. If you turn then to tab 70, exhibit 5873.
So, just this document,
Yes.
it appears to me, looking at the face of it, that it was with respect to something other than the Robodebt scheme.
Yes. To put it in broader context, Mr Porter, at this point in time, you had sought and received briefings from Ms Wilson and others in the department about broadly the concept of reforming the welfare system.
Yeah, coarsely summarised, there were a large number of payments, 55 supplements is one of the PDFs that's noted here. There had been for many years recommendations to condense and consolidate that number of payments, and that's an oversimplification, but it was a large project of reform along those lines.
Yes. In that context, there was incidental reference to some features of the Robodebt scheme. Can I take you to tab 70, which is a document, a lengthy document entitled The Case for Reform, and
Yes.
it appears to relate to a meeting anticipated to be held between you and the Prime Minister. If not 8 August, then sometime in August, according to the covering
Yes.
email. Right. Can I take you to the page ending .6000? Well, oh, sorry. Firstly, tab 73.
Could my friend mention the exhibit number to assist us? Thank you.
Exhibit 5876 is the exhibit.
Or 4876.
5876. I'm told that's not right. 4876, thank you.
What tab are we under now?
I was going to say, you should have known Ms Hogendoren would be right.
Yes, and that I didn't tender that many exhibits earlier.
Okay. The tab number for Mr Porter, it was 73, wasn't it?
Tab 73, yes. The document, and you can see it on the screen, Mr Porter, deals with the question of legislation that had been passed in respect of your department and then legislation introduced but not passed, 2 pages in or 3 pages in.
Yes.
The top right corner is .6000. And Mr. Porter, I'll take you to item 10 on the list. You referred earlier to budget measures, and some of those had related legislative relevance. That is, legislation needed to be passed to implement them. These were 2 of those in which he might have received additional information about the scheme in a broad sense.
Well, possibly, but I don't specifically recall, other than this document likely being before me, the removal of the 6-year statute of limitation. I recall the departure of prohibition orders.
Yes. And do you recall that these measures were introduced from 1 January 2017?
Not specifically, but I've no reason to dispute that.
All right. Point 9 refers to the interest charge bill. Do you have a recollection about the introduction of a general interest charge in respect of social security debts?
Broadly, yes.
And is it your recollection that those 2 measures that you do have a broad recollection of, the departure prohibition orders and the general interest charge, were introduced as incentives for persons to make repayments for social security debts?
When you say incentives, my recollection is that the departure prohibition order was about stopping people from leaving the country if they had outstanding debts. So it was a mechanism to ensure greater amounts of debt recovery. The application of a general interest charge to debts of ex-recipients of social security and family assistance payments, I think that, yeah, that could be properly described as an incentive to pay monies, yes.
Yes. Can I take you now to tab 87, exhibit 4890? Before I move to the detail of the email, Mr. Porter, as you outline in your statement, there was an increase in criticism of the debt recovery scheme undertaken by DHS in December 2016.
Yes.
And it coincided to some extent with leave undertaken by Mr. Tudge at the time.
Yes.
That is spanning the Christmas New Year period and into early January.
Yes.
And in that context, you acted or assumed responsibility for the ministerial role of the Department of Human Services.
That's right, in addition to my
role, yep. Continuing your other obligation. And the responsibility that you assumed while Mr. Tudge was on leave included having to get across the issues that were being raised in the media and to respond to media, either by way of interviews or the like, and engage with the department itself.
Yes.
That is DHS itself. And it is in that context that this email was sent to the various persons within it.
Yes.
The first email is over the page, .0399, from Mr. Tudge's media advisor to Mr. Donnellan, who I understand was your media advisor or senior media advisor.
Yes, Kevin Donnellan. Yep.
Donnellan, thank you. It refers to the current media coverage and some points for emphasis in respect of the sequence of letters that were being sent under the debt recovery program.
Yes.
Right. The email was then sent from Mr. Donnellan to you on the 28th of December 2016. At the bottom of the first page, he refers to you in terms which suggest that you were also on leave.
Well, you try and have light duties over that period of Christmas, so I wasn't attending the office 9 to 5 every day, but I wasn't on leave. So if you need to take leave, you need to formally request it, have a minister acting. So I think that description's a bit generic and colloquial. I wasn't on leave.
Right. The email identifies a number of issues. The fourth is the one of relevance to the Commission. Ms Burney was the Labor member who I think had the shadow role to Mr Tudge or yourself.
Yes.
Yes. And the story which is referred to there was a story published in The Guardian where Ms Burney called, Ms Burney called for the suspension of the debt recovery scheme.
Yes.
Right. There was a reference to Hank Yongen in that subparagraph. Do you recall Mr Yongen?
That's in subparagraph 4?
Yes.
Yes, so Mr Yongen, as I recall it, was very senior at Centrelink.
Right. And regularly engaging in interviews or talkback radio, that sort of thing on behalf of the department?
Correct, on those sort of operational matters that Centrelink would be responsible for, yes.
If we go then to the next email from Mr Donnellan. It attributes to you that you would like a brief from DHS on the issue, in particular covering, and then there are a series of subdot points.
Yes.
The first there refers to averaging out of income provided by the ATO to Centrelink, impacting on people who only earned income seasonally, for example, students. The second is, it appears Centrelink is averaging income over 26 fortnights, then raising debts. What do you recall of your thinking at the time?
Well, I was coming into this issue fairly cold, if I can describe it that way. So, councillors, you've suggested my involvement with the OCI program had been in a very broad way through the macro budgetary sense. I wasn't familiar with the operational mechanics of it. Based on the article that's referred there at number 4, I was striving to get an understanding of some of the basic fundamental mechanics of the program, and then because there'd been complaints that had come in, my first line of thinking was to try and contextualise how many complaints as a percentage of the total transactions that we were talking about, to get, in my own mind, a sense as to the substance of the issue, whether it was substantial or whether these were a small number of complaints in a large pool of transactions.
In terms of the question of averaging, at least on the limited information that you had at the time, which I think included the link to the Guardian article, you were either able to extract or identify a question that related to how debts were being raised in that mathematical sense.
Yes.
Yes.
Well, not raised
No?
No. So I understand by the term raise you mean when the debt is formally issued or comes into being. My understanding of the process at this time was about the issuing of the initial correspondence letter that then commenced a process which involved people responding and providing information. So I was interested in that starting of the process, is my recollection.
Okay. I may have just been taking the reference to averaging income over 26 fortnights and then raising debts as attributable to your state of mind at the time, but it's how it appears there, that's all.
Yeah, well, obviously that's come from me speaking to my Chief of Staff. I have a recollection as to what was my primary concern at this first point in time when I was dealing with the issue in a substantive way. And people obviously use that term raising differently, but...
Yes. All right. The bottom of the page refers to Alan's TPs are attached. Do you see that right in the last line? That's Mr Tudge's talking points, which have been prepared by his office for him.
Well, the talking points were generally prepared by the department.
Oh, sorry, quite right, yes. Prepared by the department and reviewed by his advisors.
Yes.
For him. I'll just take you briefly to those. They are behind tab 90, exhibit 4893.
Yes.
And if you still have your hand at tab 87, you'll see that the title of the attachment at 87, Q&A's online debt and compliance tool, has some resemblance to the title of the document at tab 90, which is of course dated at an earlier point in time. Again, these talking points provided you with some additional information about the scheme shortly before New Year's Day.
They did.
All right. But as you can see from a review of them, there is limited reference to the concept of averaging in the process of raising a debt, that is the end result.
Limited, virtually none, but yes, very limited.
Thank you. Did you, during your time in late December into early January, while you were acting for Mr Tudge, gain the impression that DHS was reluctant to emphasise the stage at which averaging was involved in all of the publications, public information that was presented?
I don't think I formed that view in the early stage of that period of acting. Perhaps if it assists, if I can provide a general recollection of that period of acting. So I started acting in about 28 December. I think it ended around the 10th of January. I received obviously these complaints and then media articles which clearly required a response. I recall going through over that period from the 28th of December to the 10th of January, sort of an acceptance of the position and talking points. That then turned at some point into circumspection. Then I became sceptical. In the end, I was extraordinarily frustrated with the level of information and detail being provided. And as I got further towards the end of that period of acting, there was a greater number of queries and inquiries that were being generated by me and my staff in my office. So as a general picture, that's my recollection. Whether I would describe it as having formed in the first days of acting 28, 29, 30, that there was some reticence to provide information about averaging, I don't think I would go that far, but there was a point I became very frustrated at the level of information that was being provided.
Yes. If I take you to tab 91, exhibit 4894, This is an email, of course, it doesn't include you, but it refers to talking points requested by your office.
Yes.
Not surprisingly, because the previous version you were given were dated 4 December 2016. The specific nature of your request, or your request, is given some specificity towards the second half of the paragraph by reference to the Guardian article today, which triggered interest from 2GB and Radio National, and that while you were across the 1 January pension changes, you were not fully across this topic, which is also trending heavily on Twitter. Firstly, does that accord with your recollection of your knowledge at the time?
Yes.
And you appreciated, I take it, the significance of potential adverse media in respect of this program at a time when the government was introducing pension changes or changes to pensioners' entitlements, which could also be perceived in a negative light or attract some criticism.
Yes, I didn't link the two. I mean, the reality is that criticisms over any changes in the welfare system generated at the early points invariably criticism. But I do recall, as it says there, not being fully across the topic. I recall around about this time calling Finn Pratt, my secretary, and sort of putting to him if he knew much about it and the rollout and the operational mechanics of it.
Just on that point of your interaction with Mr. Pratt, do you recall telephoning him or speaking to him in person at this point in time, that is late December 2016, and saying words to the effect of what the hell's going on here?
I heard one of the few parts of the Royal Commission that I heard was Finn Pratt saying that, and it certainly accords with my recollection. And my recollection is also that he, a bit like myself, was not fully across the topic.
Do you recall that he responded in a general way by directing you to persons within DHS who might be able to answer the question? Can I go then to the talking points which you requested about the online compliance program, which appear at tab 92, exhibit 4895?
Yes.
If you turn to page 3 of 10 at the bottom right corner, dot 0081 at the top, the question is it true that debts are being incorrectly raised against customers due to their employment reporting their income as being earned over 12 months when in fact they've only worked part of the year and had income support for part of the year? Now, did you understand that that was a question generated in response to the email I took you to earlier, where in response to the Guardian article there was the suggestion of averaging over the year, even though someone might have only worked for part of the year?
Well, I'm not sure I would have had that very specific link in my mind, but it seemed like my broad recollections with the issues that were being raised, it was an obvious question to ask.
And if it wasn't in response to something you had said, the department had identified the obviousness of the question in response to media criticisms and developed these points. All right.
With respect to that, though, and I recall this document, and the final dot point then says if a person thinks the decision is wrong, they have the right to ask for review and have further appeal options. These review and appeal rights are outlined in the department's letters and so forth. And the former dot points talk about encouraging customers to take a role in ensuring their record is accurate. What I took from that at the time was that the averaging was the start of the process. The call for information was based on the average data.
And that the raising of the debt in the strict sense, that is the letter saying you have a debt, did you understand that to involve averaging at?
I didn't understand how that occurred.
Right. Certainly, it's not identified in any of the dot points in the answer to the question here.
No, and because these media responses were about the receipt of letters and people's initial responses and actions to them, at least in terms of the triaging of issues at the time, I was concerned to understand the nature of the letters, what they sought to do, what process they enlivened.
Certainly, well, perhaps not certainly, but is it your recollection that these talking points informed your responses in media interviews in early January?
Very much so.
That is, where questions arose about the role played by averaging in the process, you were able to respond, but in terms which didn't directly identify the point at which averaging was involved and how that led to the raising of a debt.
Yes.
On one view of things, it gave rise to the appearance that the direct question was being avoided. Would you agree?
The appearance that I was avoiding the direct question, or?
Yes.
Well, it could easily give that appearance.
Yes.
And looking back on it, it appears that these talking points kind of avoid that direct question as well. But at that point in time, I'm basing my responses very much on these talking points, not having a deep background in the operational mechanics of it.
Thank you. Commissioner, I am reminded of the time.
If you want to finish your point, we can end a little later and come back a little later.
I'll be moving on to another document, which is the next tab, but I'm receiving some instructions about Mr. Porter's diary. I'm told that there have been printouts of the spreadsheet, which can be circulated and reviewed over the lunch break.
All right, well, that's probably a good thing because we're moving to 2017, it sounds like. All right, well, we'll come back at 2 then. Thank you.
All rise. The Commission stands adjourned until 2 p.m. The Royal Commission is now in session. Please be seated.
Yes, Mr Moses.
Royal Commissioner, thank you. Just want to put on the record that during the luncheon adjournment, with the permission of counsel assisting, we provided to Mr Porter a copy of the document that Ms Hogan-Doran referred to earlier. Can I indicate to the Commission that whoever gave instructions to Ms Hogan-Doran to put to you what she did in terms of this document and what it is meant to contain hasn't really given accurate instructions. First of all, it contains material in there, including a reference to what is said to be a meeting with the Prime Minister on the 13th of January, which wasn't previously provided to us. But more importantly, we were told moments ago that the document doesn't actually reflect the dates upon which meetings were said to have taken place, but rather the metadata entry dates in respect of these matters. And we then received, in effect, about 400 pages of documents said to be the underlying documents relating to these. Some of them, for the first time, disclosed the names of attendees at meetings with then Minister Porter, in which explanations were given about the scheme. And the only reason I'm raising this is a matter of complaint, to say that where one of the critical issues raised by Mr Porter in his statement is that a representation was made to him by an official from the department that there was a legislative underpinning for this matter, and there was in effect advice to that effect. One would have thought you'd want to know who was at these meetings to find out who made that representation, because it then may be linked to whoever produced the 10th of January instructions to the AGS. That went nowhere. But our concern is, again, from a question of procedural fairness, this should have been readily available some time ago, or an explanation provided to us. It wasn't. So what we do know now is they can't provide us with the diaries of the Minister for that period. They may have to work out in the future how they properly archive diaries so this doesn't happen again. It might be a recommendation you make. But we're in a position now where the Minister, the former Minister, has given you a statement saying he had meetings, can't recall who was in attendance, and certain things were said, but we can't now further assist because we haven't got the diaries. And this is something that we've been trying to get for some time. The Royal Commission, as I said, directed us to the AGS and asked them to assist. But for this to happen on the day Mr Porter's giving evidence isn't fair in circumstances where he's being asked to assist the Commission. That's all I wish to put on the record.
Okay, but are you asking for anything to happen, an adjournment of his evidence? Or...
No, because we want this matter to finalise. But what we do want is an affidavit from somebody from the Commonwealth to explain this question about the diary entries for that period. Because if there are actual diaries that do exist that they haven't found, then that may further the inquiries of the Commission or assist in terms of its evaluation of Mr Porter's evidence concerning this matter. But we want the matter to proceed today. We're not asking for an adjournment. We're just asking that there be something by way of evidence put before you as to how they've come to prepare this document and why it is they can't provide a diary of a Minister of the Commonwealth in respect of relevant periods so that we know what's going on here.
Okay, well, the Commission will work out what it wants the Commonwealth to provide in that regard. But I'll just see what Ms Hogan-Doran has got to say. Are you in a position to address that, Ms Hogan-Doran?
In part, Commissioner. The first is that, as you would have seen, I read out the instructions I had, and those instructions were believed by me and those
all right, no, if
assisting
you
me. Deal with that issue, put that to one side. As I understand it, the aid memoir is not of assistance, and it should be put to one side. In terms of the underlying documents, I'll take further instructions. Obviously, we're here to try to assist. I understand the complaint has been raised, but the intent is to press on. I don't see presently an issue in pressing on.
All right, thank you. Mr Porter, I gather you want to say that various things were said to you. Do you not remember who said them? What's the basic issue?
Well, I think that this is placed in both the written statements I've provided, but during that key period from 28 December to on or about 10 January, there are a series of meetings by teleconference. I just can't now recall the precise dates and times and who was in attendance at them. In at least one respect, there was something I think that is relevant and important said. I just don't have without the aid of the diaries, any chance really of saying who that might be. And it may be even with the assistance of the diaries, notating who was there, I couldn't say with any certainty with that assistance. But I can't put it any higher than that.
Okay.
I'm certainly wanting to press on, and I'll do my best in the recollection of the types and meetings that occurred and the general time frame for them, but I can't be accurate with that.
Right, thank you for that. Are you likely to come up with anything better or no? You've done all you can or?
Commissioner, I'm having urgent instructions sought. In relation to what my friend said in respect of a meeting on the 13th of January, if I could just indicate the difficulty with the document is that rather than indicating a meeting invitation for a particular date, the document evidences communication sent on that date. Yeah. So it may be for a meeting to be held in a later period, and that in as much as it indicates there was or there wasn't a meeting on the 13th of January set, that document does not confirm that.
Mm-hmm. All right, nobody keeps a paper diary anymore? We'll press on, Mr Gregory.
Thank you, Commissioner. 2 matters of housekeeping. Firstly, I've determined that it's not necessary to hear oral evidence from Ms Melinda Smith from the Australian Taxation Office in respect of the topic of garnishes.
That was tomorrow.
That was tomorrow. Her evidence will be tendered, that is a statement and attachments, and I ask that she be excused from the summons.
Yes, she's excused from the summons.
And the second relates to the exhibits to which I've been referring during the examination of Mr Porter. I haven't tendered those.
Oh, okay. I had...
They number 4825 on the draft through to 5090.
Right, 4825, and it's the entirety of the list, is it?
Entirety of the list, and it includes...
90. Mm-hmm.
Yes, includes Ms Richards' exhibits for later this afternoon, hopefully.
Yes, they're admitted with the numbers they bear in the list. Yes, I ask that exhibit 4896 be placed on the screen. Mr Porter, if you go to tab 93. Continuing the sequence, you'll see that the email at the top of the screen is 29 December, as is the email immediately below it, but it relates to the email trail from the 28th of December, the previous day. Particularly, the questions that were asked in the previous document have been answered in this document, even though this document is ultimately not forwarded to you. All right.
Yes, I've seen this document before and it's internal. I can describe it that way, yeah. To the department.
That is, yes. And that is the Human Services Department.
Yeah. When I say I've seen it before in preparation for today.
Yes. The passage in blue under the question averaging out of income provided by ATO to Centrelink impacting people who only earned income seasonally is answered in those terms. Firstly, even though it's an internal email, do you recall being given information to this effect?
No.
And in that event, does that explain why, when you were involved in various media interviews in early January, you weren't addressing the questioning of the point of time in which averaging was part of the process?
I'd need to be taken to those interviews, but what I can say is I just wasn't aware of this information to the best of my recollection.
Right. Can I take you then to tab 100, exhibit 4903. On its face, this is an email which is sent to you by Mr Donnellan, attaching copies of the letters which were involved in the process which were the subject of criticism. The exhibit which is tendered, Commissioner, and the document in the bundle before Mr Porter doesn't include the attachments. They have been provided, but I will tender the letters as Exhibit 4903 capital A.
All right, 4903A.
Mr Porter, can you just briefly look at the hard copy of the documents you were just given, which are 3 letters.
Yes.
Do you recall requesting copies of the letters which were sent in this period of time generally?
I recall seeing the letters. My broad recollection is that I saw them after this date of 3 January, but I could not be certain about that.
The date 3 January, you may recall, was a day you participated in a Radio National interview, I think, from Perth in the morning.
Yes, that's right.
It take you to the transcript of your interview. It is behind tab 102. In my copy of the bundle, it's in the start of volume 2.
Yes.
Exhibit 4905. Thank you. Mr Porter, in the preparation for your evidence, have you listened to that interview or perused the transcript of?
I've had the transcript brought to my attention, I believe. I've not listened to it.
Thank you. If you go to page 2 of the transcript, the question in the second half of the page refers to the onus of proof. In the context of the passage of time, your answer refers to the system based on mutual obligation, that is the basic responsibility of the recipient of welfare, to provide information to the government to ensure that taxpayer monies have been properly spent. Can I take that point initially? The concept of mutual obligation as you described it there, did you have resort to any background information which allowed you to make that answer, or are you just making a general statement?
Sorry, which page are we on?
Page 2,
Yep.
paragraph 2, the concept of mutual obligation to which you refer.
Second last paragraph.
Second last paragraph.
Sorry.
Yes.
just a fairly standard description of the welfare system in broad generic terms.
Yes. In this particular case, though, in the context of the time frame which is referred to in the question, and at least your understanding at this point that this measure was going back a number of years to get people to confirm information from a time when they had previously received benefits.
Yes.
Did you, beyond this general proposition, seek information from DHS or your own department about the foundation on which people were required to respond to the letters?
The foundation, do you mean the statutory foundation?
Yes.
No.
Right. Was it something that you turned your mind to at any point?
No.
You may not immediately recall, and we can go to the document if you wish, but one of the questions answered by the Solicitor General in the Advice 15 of 2019 was the legal obligation upon persons to respond to the letters, examples of which we've just seen attached to that email.
Yes.
And the opinion of the Solicitor General was that any obligation could only arise there was no general obligation, as it were, in this particular context. Rather, the obligation, if it arose, would arise from a specific statutory provision. Did you see any information from the department at the time which referred to or alluded to the basis on which it was asserting an obligation that people had to respond to letters?
No.
The earlier question I wanted to ask was whether in the information you sought after Mr Tudge returned, that is from about the 10th of January through to later in the month when you said you became frustrated with the department's response or lack of response, during that period, do you recall the question of the obligation to respond to letters being a point at which there was any discussion?
Not that I recall, no. I recall with the letters that I can't recall when I came to first read them or consider them in a detailed way in the context of what I came to understand was the process. But I recall to the end of that acting period forming a judgment that the letters weren't drafted in a way that was particularly fit for the purpose. And I recall later after that period going to quite some effort with Minister Tudge to redraft the letters. So I recall early descriptions of the letters. Obviously our office received them. I also recall at some point in time getting letters that were sent to individuals, like actual letters. And I have a vague recollection that they were with respect to individuals that were raised in the media. But I don't recall any information about the statutory basis for sending letters.
As a lawyer, if you were going to contemplate the contents of the letters, didn't you need to know the statutory parameters for them?
Well, I mean, in hindsight, it's a fair question to ask, but at the time things are moving very quickly, and to interrogate the statutory basis of every single thing that was occurring just did not occur to me insofar as the fact that these things had been obviously and regularly occurring for some period of time. I guess I'd just add to that essential description of the mutual obligation system. The welfare system is based upon the provision of income information to the government to fall into a category and receive welfare. And Council rightly makes the point that these were requests for information that were not contemporaneous with the point at time at which the person was actually receiving welfare. So that's a distinction. But the point of the fact that regularly information was sought and received from welfare recipients about their income would have strengthened in my mind that there was a lawful basis for that it wasn't a question that was in my mind.
Well, you could seek information from welfare recipients under the provisions of the Act. You could give them a notice and say, we want this information. That didn't happen here because there was no attempt to rely on the Act or give a notice under the Act. And apart from that, apart from the obligation to report any change in income that the person had at the time they were receiving benefit, there was nothing, it seems.
Commissioner, I accept that. My response would be that during that period of acting, come into the issue cold, dealing with what were a multitude of issues and problems arising with the process that my office and I were identifying on a daily basis. There were many that appeared to me, many queries that went at that time and afterwards. This was not one of them. Okay. Or the one that you raised was not one of them.
Another issue which was raised with you during the interview is on page 3, dot 0687. The first question on the page relates to the question of how annual income relates to fortnightly income. My summary.
Yes.
You, of course, understood, as I think you said earlier, that the entitlement to welfare payments was assessed on a fortnightly basis generally or in most cases.
Yes.
Did you understand that the question was directed to how one arrives at an assessment of fortnightly income by reference to information over a broader period of time described as annual income?
Yes.
Your response, I suggest, doesn't answer the question of which was being asked.
Well, yes and no. I accept that interpretation of it. Equally, with the limited knowledge and understanding and talking points I have, I'm responding in a way which I think goes to the issue of what was my understanding, that where the discrepancy arose based on the aggregated data you'll see there in the final paragraph response, that we are checking on best information that we have available that a person's payment has been received properly. Now, I can say that what was in my mind at that time is that I understand the question, but I'm relaying the fact that this is a process that then involved seeking further information about that distribution of income in the period.
All right.
Was in 80% of the instances of compliance letters going out, there's been a debt raised for the Commonwealth? Was that in your talking points?
Oh, yes.
Because it wasn't, of course, true.
Well, there were lots of things in those talking points that through this process and information from my lawyers provided me from this process, I now understand were inaccurate or untrue. I placed enormous reliance, I must say, Commissioner, on the figure that was in those talking points, which was about the percentage of complaints. I can't remember precisely what it was, but it was 0.16%, but it was a very, very small figure. And my experience, at least to that point in time, across those portfolios was that a very good starting indicator of whether or not the problem was substantial was the number of complaints per letter or interaction or process. I've come to understand through my lawyers that that was incorrect.
I will take you to page 5, dot 0689. The complaint rate of 0.16% is referred in your second answer on the page.
Yes, yeah, I see that.
You see that there? More particularly, the question at the top of the page, how important is this debt recovery to the budget bottom line? You responded in the terms which are set out there that $4 billion over 4 years is evidently a very significant amount of money that is helping us get back to surplus.
That's right, but my recollection is that that $4 billion was a composite figure for things other than merely OCI, but yes.
In part, a reflection of election commitments from June the previous year, which I've taken you to.
I wouldn't describe them as commitments, but announcements, yes.
Announcements. Thank you.
The reason I wouldn't describe them as commitments is that they were announcements about forward estimates of savings, which are ultimately variable. But
yes, all right. And subject to a process, a budgetary process in any event.
that's right.
Nonetheless, would you agree that a budget announcement, or an election announcement in those terms, and then the MyEFO processes which followed in the latter half of 2016, provided a degree of impetus to continue this scheme despite the criticisms because of its relevance to budget?
I probably wouldn't accept that for this reason, that after that period in January, when the procedural problems were manifested to me, and I think to Minister Tudge became known, throughout the course of 2017, when the operation was handed back to Minister Tudge, there were a range of very considerable changes made. Now, one of the effects of those changes was that the estimated out-year savings very drastically decreased, and particularly in the next year. And effectively that was Minister Tudge recommending, and as social services, me agreeing, and then taking through the ERC process the decrease in savings that was to occur, because the system, in my recollection, was effectively paused and reverted to the manual PAYG system for some considerable period of time, 6 to 9 months or longer.
Was there any sense, to your recollection, on your part, that because this was a budget measure introduced by Mr Morrison, who had gone on to become the Treasurer, that it was more difficult to tell him as Treasurer that there might be some difficulties with the scheme that went to the heart of it?
Absolutely not. Look, if I can take your counsel back to that document at 61, which was the sort of Gantt chart of savings.
Yes.
So I can say as Minister for Social Services, the period of time when we were on a trajectory to a budget surplus, there was significant pressure and targets to deliver savings in the portfolio. And that sort of document that detailed the savings wasn't sort of drafted as a boast. In a way, it was self-protection, because there were so many savings that had been garnered out of the social service portfolio. I was very careful to keep expectations realistic about what could be expected of the portfolio in the future and what could be expected as to delivery against these. So my view about savings measures were that if they became untenable or were no longer effective, that they would be paused or reviewed. I didn't feel personally any pressure at all, or because of who might have designed the original program, to insist on its continuing in circumstances where, to me as a minister, it appeared it shouldn't.
Mr Porter, my attention's been drawn to a document for January 2017. It won't be in your bundle, and I'm not sure if you've seen it before. It is Exhibit 4657. Commissioner, I think it was tendered through Mr Tudge.
Oh, okay.
It makes a reference to you, Mr Porter, and I'd ask that it be brought up on the screen.
And I think my associate's going to find the hard copy.
The email at the bottom half of the page, which occurred first in time, is again an internal departmental email from Ms Karen Harfield to Ms Golightly. The subject is averaging income, and it appears as though it's a forwarded email, although it's the only document produced. And it contains an explanation of assessment methodology brackets algorithm. The email refers to the concept of averaging income and asserts that it's been around since at least 1981.
Yes.
The second paragraph says that in the last 5 years, DHS has moved to a more proactive early intervention methodology for compliance. And that
Would you like a hard copy, Mr Porter?
It would assist, but I can keep looking at this as we go.
Thank you. The second paragraph in the email asserts there is now a requirement for the customer to provide their correct information rather than DHS sourcing it directly from the employer. It asserts the methodology for calculating debts or assessing presumably income and calculating a debt has not changed, and that averaging is only used where the customer does not provide detailed information. And finally, it makes a reference to the Guide to Social Security Law, which provides for averaging to occur in the absence of other information. A number of points are raised.
Yes.
In terms of your recollection, were you aware that your department produced the Guide to Social Security Law to be followed by DHS when they implemented measures?
I can't say. I think that the document that you're talking about that was, without seeing it, I couldn't tell you whether I was familiar with it. I think I know the document.
Were you aware that the SS produced a guidance document for the application of processes carried out by DHS?
I can picture a document which was stapled in the middle and looked like almost a pamphlet form of document, and I recall that document was available both to the departments, but also it was a document that was regularly used by customers in Centrelink, and I seem to recall that was headed a guideline to welfare payments. So that's what I'm thinking of, but in terms of some kind of internal department document, I can't say that I readily recall it.
The reference to you is at the email at the top of the page from Ms Golightly to others. One of the people there is Mark Wood, who was an advisor to then Minister Tudge.
Yes.
And that's to whom the email appears to be addressed. You can see the terms in which you are referenced.
Yes.
Does this email prompt a recollection on your part where you sought information about what's been described here as an algorithm, but appears to relate to the assessment or the assessment methodology in the second email?
So I recall Mark Wood. I recall having conversations with him during this period of time. This email exchange is 4 January 2017. So it doesn't surprise me that there's a request for information coming in as I'm striving to understand the system at this period of time, that he has gone back to the department. I can't ever remember using the word algorithm or having the process explained to me in the use of that word. I can't recall ever receiving written correspondence of the form or duplicating the form at the bottom of that email. I've never seen it before. I'd be speculating about the way in which Mark Wood relayed this information to me if he did, but it would likely have been by phone. reading that information at the bottom of the page now, there's nothing in it that was sort of inconsistent with the information that I was being provided with at the time orally.
Thank you.
Wouldn't alarm you that it said, I haven't got it in front of me, but something to the effect of the Social Security Act provides for income to be looked at when it's earned, derived or received. But you don't always know this, so we've got to do something with it.
Well, Commissioner, your question is, would it concern me if I received that information? I mean, I don't know. I've not read this email until today, never seen it before today, to the best of my recollection. I, at this point in time, was obviously going to staff in Minister Tudge's office and trying to extract as much information as I could about the processes. How the content of this email, if it was relayed to me, was relayed to me, I just can't recall, but I don't believe
Because the tenor of it seems to be, oh, well, if we can't make the Act work, we'll do whatever it takes, really.
Which part of it do you say has that tenor?
I haven't got it right in front of me. Maybe the bottom of it could be moved up. Thank you. So, the legislation, the Social Security Act, refers to assessing applying income when it's first earned, derived or received. However, the practicality is that this is not always known. The choice would be to ignore it or apply it in the best way available.
I don't recall having those words ever put to me.
Fair enough. But do you agree that they do have the tenor I'm suggesting, which is if the Act doesn't apply to the situation, you just do the best you can?
That's certainly one meaning you could take from it. I find it Delphic, to be honest.
Mr. Porter, just to continue the chronology a little longer, can I take you to tab 109, Exhibit 4661. It should appear to be an email from Ms. Golightly to Mr. Tudge, Ms. Campbell and Mr. Jackson.
Yes.
The date is 7 January 2017. The attachment is OCI Ministerial TPs, that's talking points, and it is addressed to Mr. Tudge from Ms. Golightly. In response to your request this morning for the talking points and facts and figures the Department has provided to Minister Porter and Hank, please find attached a consolidated document which pulls together all the info which in reality has been through various individual requests or responses to media inquiries. The attachment is at tab 110 and it is an updated version of the document it seems provided to you earlier, Exhibit 4662.
The document that I saw, so the earlier version of the talking points, which tab is that under? Just so I can bring that up as well.
We'll get that for you, Mr. Porter. Again, taking you to the particular point of relevance to the accuracy of the calculation of debts. Page 4 of 16, .6585. Questions and answers at the bottom of the page. And over to the top of the next page.
Yes, I'll just read that. Yes, I've read that.
The earlier version, 28 December 16, is behind tab 92, which will be at the end of the previous volume.
Thank you.
Exhibit 4895. There is some variation, but would you agree with me the material generated by the department up to the date on the document, 7 January 2017, still did not directly answer the question that it asked of itself?
I would agree that those dot points don't engage fully with the question.
From the information that you had gathered up to about 7 January, 8 January 2017, did you come to the view that the averaging process was involved in the calculation of debts where persons were not engaged with the process online?
I think in my written statement I described not knowing precisely when I came to an understanding about the use of income averaging. It was towards the end of this period that I understood it played a role. My best recollection is that my understanding about the role was at the commencement of the process, that it was used as the trigger to then seek explanations from people about the discrepancy. I don't believe at this point in time I had an understanding of the way in which it was applied to raise debts. That is to say to...
In the final stage?
Yes.
Can I take you to tab 108? We move just a couple of days ahead now to 9 January 2017, Exhibit 261. For context, Mr Porter, this is an email between people within the Australian Taxation Office.
Yes.
And it includes, I think, Secretary Campbell's executive assistant, Ben Kelly.
Yes.
But otherwise, they only appear to be names within the ATO.
So this is from someone at the ATO?
Yes.
Yes.
Two others within the ATO, and I think Greg Williams at that point was a Deputy Commissioner of Taxation. But you are referred to in it.
Yes.
Again, it refers to Mr Scott Britton, and the content of it clearly conveys that you were in a meeting with him at that time.
Okay, and what was his role or position?
I'm inclined to say General Manager within DHS.
Right.
But he might have been a branch manager.
Yep.
But in any event, at a high level,
Yep. So
below Deputy Secretary within DHS.
No reason to dispute that he was one of the people that we were meeting with or receiving information from. Yeah.
Yes, that's right. And the information which is sought relates to the collection of information that is sought by Ben Lumley at DHS, relates to the collection of information dealing with employer and employee information
Yes.
That suggests, and I'm asking you to exhaust your memory, whether you recall that these topics specifically were raised in terms of information you sought, or whether you can recall generally that you were continuing to ask questions about how the scheme operated.
Yes. So it says Minister Porter, who asked if Centrelink could be given more frequent data on a person's income, then wanted him to confirm his understanding as brackets, which was correct, close brackets. So it was certainly at this time, towards the end of that acting period, that I'm continuing to strive to understand the processes, continuing to identify deficiencies in the processes around the letter. And I couldn't say with certainty if this is a perfectly accurate reflection of what I asked, because obviously it's a second-hand relaying of what I was asking, but I've no doubt that I would have been asking these types of questions. Where it says could be given more frequent data on a person's income, I couldn't say with certainty now whether my mind was directed towards data on a person's income from the ATO or from employers or from the person, but I can say I was striving to understand the role it was playing.
One interpretation of the way in which it's described here is directed towards whether income in periods less than annual PAYG data measures could be obtained from the ATO.
Yes.
In respect of fortnightly entitlements. Well, sorry, in relation to fortnightly entitlements.
Yes, that's certainly one interpretation. And hearing you say that, I recall that one of the issues that I was striving to understand was that breakdown, but not merely fortnights, the issue about what would happen across financial years and so forth.
Yes, okay. Do you recall where you got to in terms of your understanding of the scheme in respect of the stage at which averaging was applied in relation to raising a debt?
Not with any specificity. I can say that it was imperfect by the time I ceased to act in the position. I can say at its highest, I understood, based on the meetings, the oral provision of information that I'd had with DHS and DSS people, that it was being used at high volume for the trigger letter, if I can describe it that, the first stage in the process to identify the discrepancy. But I think it's fairly accurate to say that I didn't understand precisely how the debt was ultimately being issued and completed.
It was in the context of the documents that we have gone through and your evidence to this point that the question of whether legal advice about the scheme had been obtained, and that came up between you and someone, it seems, at the Department of Human Services.
Yes.
Can I approach the topic this way and take you to tab 4 of volume 1? It is exhibit 4288.
Yes.
Page 10, the last page. That's not the document, I'm sorry.
So that's my written.
This is the summary of media statements or media releases in relation to the Robodebt scheme, the attachment to your second statement. 4828. I'm sorry.
I'm a bit confused. So which tab am I under?
4, I hope.
Yes. Yes.
You have the table?
Yes.
It's the last page, Mr. Porter. And now that I've given the correct number, it should also appear on the screen. Yes. On the last page of the document, the date 31 May 2020 is in the left column. The type of media statement or release is in the second column, the ABC Insiders program. And you quote there a statement that you made about advice. That is the first quote there.
Yes.
Now, this is, of course, a number of years later, over 3 years later.
Yes.
When was the first occasion that you had to recall the conversation back in January 2017?
That I had to recall it?
Yes.
That I had to recall it. I always recalled it.
Okay. It didn't seem to feature in any of the media that followed January 2017 that you participated in when there was ever a challenge to the assertion that the scheme shouldn't continue. That is, I'm saying it only... Your public statement about the conversation in respect of the advice years earlier only arose, as it were, soon after the scheme was ceased fully and perhaps 6 months after the Solicitor General's advice.
Well, if you want to take me to individual interviews, I mean, the suggestion is that it would have been appropriately raised in other media opportunities earlier. Is that the suggestion?
No, I'm not suggesting that. I'm just saying that you didn't raise it at any earlier point in time publicly until this point, when it appeared to be you were being challenged about the government's continuation of the scheme or discontinuation of it.
Indeed, on its legal basis, it seemed like it was directly engaging with the question, yes.
The advice that you referred to there, when you say we received advice, as I understand what your statement says, you are describing a statement made to you rather than the provision of an advice in written form or electronic form to you.
I'm referring to two things. Certainly that recollection of a meeting during that period where I sought an assurance and got an affirmation about the underpinnings, and also the knowledge and experience that I had by that stage that to have gone through the NPP process, this would have been scrutinised as to the issue of whether it required legislative change or not. But I firmly had in my mind that I'd put this question to people and that they'd responded affirmatively.
You describe it in detail, or more detail, in paragraph 38 of your second statement behind tab 3.
Yes. Yes.
Exhibit 4827 for the record. Yes, if that exhibit could be taken down. Now, in paragraph 38 of that statement, you refer to generally the period in which you were acting as Minister for Human Services, which covered a couple of weeks.
Yes.
Part of that period, it seems that you were based in Perth.
For almost all that period, I recall, but again, it's a little bit difficult without diaries, but yes. Perth-based, yes.
It was clear from the interview on the 3rd of January that you were in Perth when you were being interviewed.
Oh, yes, I was.
Whether or not I was had gone over east at the end of that period, I just couldn't say with certainty, but the bulk of that period was in Perth, yes.
And in terms of meetings with DHS staff, how did they take place to your recollection?
I can't recall with great specifics, but I was having phone calls and then phone calls with individuals at DSS, phone calls where there were multiple individuals with DSS, teleconferences, I guess you would call them, and then there were meetings after that.
In-person meetings as opposed?
My recollection is that there were in-person meetings, yes.
Do you recall whether they DHS staff came to Perth or you came to Canberra or Sydney?
It's one of the reasons I wanted access to my diary. I think they came to Perth, but I just couldn't be sure these years later.
If they came to Perth, that would suggest that, it might reflect two things. First, the light duties period, where you were not on leave but still based at home, and the fact that the issue was of some significance to justify high-level public servants within the department coming to you to resolve the issues that were arising at the time.
Well, yes, to both questions. And the idea of being on light duties, that ended around about getting those emails on 28 December. I was enlivened on this issue.
Yes. As you describe it in paragraph 38, the topic arose almost incidentally.
Yes.
But the representation made to you, as I understand it, was that there was, as you say, a sound legislative underpinning for the scheme as it was operating.
Yes. I mean, I've described it in that way because I think that's the most accurate way I can describe what I recollect as the transaction. But the transaction was, and it sat in the context of dealing with the immediate problems. The drafting of the letter, the difficulties that arose with respect to people to whom the letter had been addressed not receiving the letter, the difficulties that arose with banking records, gross and net figures, and there were a range of others, and these were the procedural difficulties. But I do distinctly recall putting a question in the structure of, I presume whilst we're dealing with all these things, that everyone's assured about the underpinnings or legal underpinnings. I don't know the exact language that I use, but I'm trying to describe it as the best way I can there. And I can't recall who it was who affirmed that assurance, but someone did, and I recall that it was a departmental person. I couldn't say if it was DSS or DHS, and it happened quickly, and we moved on because it just wasn't the focus of what was going on. And I had in my head, in asking that question, the fact that through an NPP process, this checklist has to be gone through about whether new legislation is needed and about whether or not the legislative underpinnings are known and sound.
Is it fair to say then that being given that assurance by either DSS or DHS persons in the presence of others, you put it to one side and got on with the balance of the issues?
Yes.
The next reference that you make to it in your supplementary statement is at paragraph 61.
Yes. Tab?
Same tab, tab 3.
Yes, 61.
Paragraph 61, page 19. And we remain on exhibit 4827.
Yes.
And it arose in the context of receiving a copy of the Solicitor General's opinion. And at that point, you instructed your senior legal advisor, noting, of course, at this point you were Attorney General.
Yes.
To press DHS for the legal advice to which you referred in paragraph 38.
Yes.
Now, the reference to DHS there, does that assist, or is the need to press DHS a reflection of your recollection that it was someone from DHS who informed you that there was advice?
So I'm relaying two different things here, and obviously I understand the importance of being accurate when you're under oath. I am relaying in paragraph 61 what I said to Michelle Hutchinson at that point in time, which was to pursue DHS. Now, that is because my best instinct about who it was who gave the affirmation was that it was from DHS. Obviously, when I'm having that conversation with Michelle Hutchinson, I'm not signing something on oath. I don't feel confident enough in that instinct because it's a vague recollection to sign off on that as a statement to the Commission. Is that distinction?
Absolutely. That is, it was, I think you said, your best instinct about the source of the information back in 2017,
Yep.
and that was reflected in your instruction to her.
In my conversation with Michelle Hutchinson, yes.
Now, the Secretary of DHS at the time, was that Ms Renee Leon?
I think that would be right, yes.
I appreciate it's not your portfolio, but you indicate there that requests were made, as you might expect, by her after you gave that direction, but the advice was not received by your office. Do you recall thinking at the time, why are we being ignored or something like that? Why can't this be produced?
Yes.
Can you elaborate?
Well, when I came to read the Solicitor General's opinion, and I recall this period in January, early January 2017 fairly well, because it was quite an unusual period. And I recall this exchange. I then read the Solicitor General's opinion. In recollection of that exchange, was perturbed at that. And I, in fact, read the Solicitor General's opinion very shortly before going to an ERC meeting where I wasn't scheduled to appear at the meeting, but as Attorney General I was asked to come along because this issue was being dealt with. That level of annoyance was part of the motivation for asking Michelle Hutchins to follow up and get them to produce whatever it was that they might have been referring to back in 2017.
Is it fair to say that there were very few occasions when you were the Attorney General when your requests were not responded to?
Well,
of this category?
It is not fair to say.
Okay.
No.
That is, you'd ask for things from time to time and they just wouldn't be delivered.
There are multiple things going on at once. Sometimes it's hard to keep track of the things you yourself have asked for. But it's not as if you say jump and people are necessarily jumping because of the portfolio that you hold.
All right. Speaking more generally then, you would expect as DSS Minister, we're going back to 2017 now, that if a Secretary of DHS or a Secretary of DSS was aware of advice which said that there wasn't a sound underpinning legislatively to the scheme, that there was a clear duty on them to bring that to your attention or Mr Tudge's attention.
Yes. And Council, I read a document in preparation for the Royal Commission and the written statements, and I think it's referred to in my second statement, but it was this summary document of all of the advices or things that stood in the role of advice on this issue that had been generated or gone to and from DHS. And I'd never seen that document before, and I just was unaware of all of these comings and goings on this issue at the interdepartmental level, if I can describe it that way.
The document to which you're referring, I think, was authored by Ms Keeling.
That's right, yes.
Thank you. I'll take you now to a few documents which demonstrate some legal considerations of the scheme. Tab 7, it is Exhibit 2. The date of the document is 18 December 2014. It predates your time as Minister. Indeed, it predates the Strengthening the Integrity of Welfare Payments, NPP and budgetary consideration. But I take it this was never drawn to your attention by your legal department at any time during your time as Minister?
No.
Do you consider it ought to have been?
Yes.
If you move then to tab 8, it is a document dated 24 January 2017. Again, it is authored by someone within DHS at the time that you were Minister. Which, depending upon which way you hold the document to the light, might provide some sort of justification for the scheme, but would you agree by reference to the date it could not have been the advice which was referred to in the conversation with you sometime in the first couple of weeks of January 2017?
Well, that must be the case because whenever that occurred, and I can't say with precision, it would have been towards the end of that acting period or shortly after. And this is the 24th of January, so yes.
I think you said it was authored by somebody in DHS, but you meant DSS.
Oh, sorry, I meant DSS.
And just for the benefit of the transcript, it's Exhibit 3.
Thank you. Were you aware of your department scurrying to get an advice together to support what had been happening?
No.
The other thing that was occurring at about the time Mr Tudge resumed is the initiation of the Commonwealth Ombudsman's own motion investigation.
Yes.
The letter to you from the Ombudsman is behind tab 121, Exhibit 4921. Mr Porter, you'll see there in that letter that was addressed to you but undoubtedly seen by many in your department. The first two points raise the question of adherence to relevant legislative requirements and the accuracy of debts being raised by the platform. The first of those given the division of responsibility between DHS and DSS that you talk about in your statement, did you consider, or do you now consider, that adherence to relative legislative requirements for the implementation of the PAYG measure, either manually or the OCI project, was the responsibility of DSS or DHS?
I don't recall this letter, but I've no doubt it was sent. I'm just reading its terms now. Is the question whether or not I consider that this letter provides insight into whose responsibility that issue was?
No, just in terms of your knowledge of the division of responsibility between the department, who you say was really responsible for the first dot point, ensuring that the scheme adhered to relevant legislative requirements. Was it your department or Mr Tudge's?
Well, it's actually not a simple question to answer, and probably a bit of both. However, so in the administrative orders arrangements, they'll list out the legislation that one minister or the other is responsible for, and certainly the Social Security Act is the responsibility of the Minister for Social Services.
But that denotation doesn't mean that the Minister for Social Services is responsible for every single action, administrative or otherwise, that occurs under the auspices of that legislation. I think probably rather than this giving the best indication as to which was the predominantly responsible department, probably the best indication as to that would arise from the NPP process and how the policy was first instituted.
Would you agree with me that the administrative arrangement orders to which you refer in your statement are cast in broad terms which don't descend to the specifics of any particular administrative action?
Indeed, and there's as between portfolios such as social services and human services, they're both totally independent independent portfolios. There is overlap and crossover, and determining who is responsible for something like the adherence to relevant legislative requirements is going to vary from situation to situation.
Are you saying that if the Minister for Social Security took the new policy proposal, which was the genesis of the scheme, to Cabinet, the responsibility for ensuring adherence to legislative requirements was his?
Well, Minister for Social Services, but that would be one...
Sorry, did I say security?
That would be one, Commissioner, that would be one indicator. And I can't recall, because I wasn't a minister at the time, whether it was Human Services or Social Services. I think it was Social Services who took the NPP. It may have been Scott Morrison as Social Services Minister at the time. So that's one indicator, but that is at the point of creation of the scheme or the policy, which is operational. Now, I'd say that it's blurry enough to say that the fair answer to your question is that both portfolios and both ministers are responsible for that issue.
I've seen a document which indicates that you attended the Expenditure Review Committee on 25 March 2015. In your capacity as Parliamentary Secretary.
So I was then Prime Minister Tony Abbott's Parliamentary Secretary. Coincidentally, Alan Tudge was the other Parliamentary Secretary. He had co-opted me onto ERC as his Parliamentary Secretary to basically, I think, in part to learn, in part to assist when he wasn't able to be physically there by listening.
I'm not suggesting that because of that reason you would recall it, but can I indicate that the Commission has heard evidence that both Senator Payne and Minister Morrison attended the ERC on that date, and that DHS had a significant role in developing the content of the NPP advanced to the ERC on that date, which was the genesis of the scheme.
That would make sense to me.
In those circumstances, can you provide any clearer answer about responsibility for legislative adherence to legislative requirements?
Both portfolios and departments, I think, were responsible. I would say predominantly after the point of NPP, it's an operational scheme, so that the operation of the scheme meets the requirements of the legislation is fundamentally a role for question and query from the Department of Human Services. But I wouldn't want to shy away from the fact that the Social Services Department and the Minister has some responsibility in that as well.
To be clear, I wasn't suggesting this document gave any indication as to who was responsible. I think Minister Tudge got an identical version.
Yep.
And also to be clear, I referred you in the table of media to 31 May 2020, the Insiders program. The earlier entry, the immediately preceding entry was 21 November, so about 2 or 3 days after, I think, the announcement following the receipt of the Solicitor General's advice. You referred to the legality of the scheme was underpinned by legal advice that was internal to the department at the time. Again, you're referring to the conversation in January 2017 in making that statement.
Yes, but also that ERC process that you've just described, because I don't independently recall it, the NPP going through, and I may well have been there as a parliamentary secretary, but what I was obviously aware of is how that process worked.
But how would you know whether the NPP went into the detail of averaging?
Well, I don't know that, but on the broad question as to whether or not the NPP was sustainably able to operate under the existing legislation or whether it required legislative change, I would have been very confident that, knowing the processes, that you would have had to have explained that and gotten over that hurdle at ERC and Cabinet to have the policy come into being.
It didn't occur to you that somebody may just not have gone into detail about averaging and how it operated, and no lawyer looking at a description of tax office data being applied is really going to appreciate quite what that means in terms of the Social Security Act?
I didn't turn my mind to what particular issues might arise in the legislative underpinnings, but I knew that you would have to be assured of those underpinnings at that time, that was something that would have been tested. Now, the Commissioner, you say that it mightn't have been tested to the degree necessary. I mean, I clearly accept that's the fact, but I was aware of that testing process.
Right, and also the other aspect is if the NPP assures people that nothing's changed in the way things are done,
well,
then that might be apt to mislead any lawyer looking at it too.
Potentially.
Mr. Porter, you've described a sense of developing frustration with the quality of information provided to you by DHS throughout January. Did that include from the Secretary, Ms Campbell?
I can't, I was frustrated with all of them. Everyone I spoke to I was frustrated with during that week or those weeks. But I can only speak in terms of senses and broad recollections, but as we went further into the process of interrogating what was actually occurring, it seemed to my office and I that the processes hadn't been very well designed. They were inefficient. There were issues and problems with them. Many of them were common sense things that, it surprised me, were extant at the time that the system went live and was scaled up. So I was very frustrated by the end of it.
What were you frustrated by? Was it the inability to get a straight answer about how it was working, or just that you thought it was a terrible system? Or what was the...
Commissioner, I was frustrated because I'd gone out and undertaken earlier media based on what were talking points and oral conversations, either direct with DHS people or relayed to me through staff in the Minister for Human Services office. The level of confidence they had was extraordinarily high, as communicated to me in the early stages. And the earlier media that I did was relaying those talking points and the confidence levels. So I felt that I'd been disserved in terms of the information that I was given to go out and do large national media on the issue. When we asked questions, it was very difficult to get engagement, in my recollection, from the questions, was the second thing that was frustrating. The third thing was that parts of the design of the system were just obviously clunky and seemed to be easily fixable, and it surprised me that they had been put together in that way. So, I went to some of these in the two written statements, but things like not having a system for being able to ascertain whether or not someone had actually received the first letter before you went back after the expiry of the 21 days and issued a debt against them. Things like the failure to disaggregate the groups that the letter was going to. But there were many others, and they seemed like things that were procedural and easily fixable, or could have been easily designed better in the first instance.
There does seem to have been an assumption in its design that people wouldn't be responding and that was fine because you went ahead and raised a debt. There doesn't seem to have been too much concern about actually getting the responses.
That's certainly an interpretation. My recollection about this issue with the receipt of letters was that in any kind of debt recovery process, there's an extent to which it's incumbent on the person seeking to recover the debt that they have some kind of assurance that the person has received the notice. And I recall in one of the meetings or teleconferences with the DHS people at this time that I was quite astonished that there was no such process in place to assure themselves that people had received the letter.
Mr. Porter, can I return to the topic of the question of legality and what you consider you ought to have been told, and that is knowledge of persons within DHS and potentially DSS. I'll take you to tab 9, exhibit 4289. The topic, no, that's not it. Uh, 4829. The topic is the Australian Institute of Administrative Law and a reference to the national conference held in Canberra in July 2017. Now, just with that broad description, do you have any recollection of the event?
No.
Are you aware generally of the Australian Institute of Administrative Law?
Yes.
The topic here was, I think, the annual conference and various attendees and speakers. While you were DSS Minister, were you aware that various persons from DHS or DSS might attend the conference?
No, but it wouldn't have been surprising to me if I...
All right. Just in the part that's pulled out, you can see a reference to Peter Hanks, QC, a barrister from Melbourne.
Yes.
Did you know of Mr Hanks?
Yes.
And how did you know of him?
I had his textbook in law.
Now,
I can't recite it to you chapter and verse, but...
What follows from that, of course, is that had you known he was giving a paper on the legality of OCI and expressing an opinion that it was not consistent with the legislative scheme, that would have been something you would have taken notice of?
I think I would have taken notice of it. I don't think that I would have in any way viewed that as some kind of definitive view. I mean, what would silks at legal conferences criticising the government was more than routine, but in the context of what had happened in those weeks in early January, I would have taken note of it.
It would have triggered, undoubtedly, some inquiries on your behalf once you had the opportunity to peruse his paper.
Well, if I'd read the paper, yes.
The conference was high on the agenda of the Chief Legal Counsel, DHS, and it's reflected in the emails which I will take you through now. At the bottom you can see an email from a Ms Carmody to Annette Mozzolino, which refers to the brochure for the AIAL conference in July, and that a couple of the sessions relate to Centrelink and debt recovery, and those are identified there.
Yes.
And you can see from the next email on 20 June that Ms Goff sends an email to Mr Stipniks confirming that Ms Mozzolino can't attend because of other commitments, but there was a request for someone to attend and report back, noting sessions of particular interest to DHS. And then there is a further email, 6 July 2017, at the top of the page. And I'll ask you to take particular note of the current AIAL president, Mr Kane Sibley from Clayton Utes, and the identification of the 4 sessions which addressed OCI at that conference, particularly in this case the session by Mr Hanks.
Okay. Who is Annette?
Musolino, the Chief
Right,
Legal...
sorry, yes.
Yes, Chief Legal Counsel. Do you recall speaking to her during any of your meetings in January 2017?
Sitting here today, I struggle to recall who she was.
All right. Can I take you to tab 11, Exhibit 4831? The response from Ms Golightly to Mr Stipniks and Jonathan Hudson asks Mr Hudson to let the Secretary know, that is Ms Campbell, and identifies that it's worth a call to the Ombudsman to get a feel for what they're going to say. Now, that was a reference to an address by Ms McLeod, who was involved in the Ombudsman's investigation earlier in the year.
And she spoke at this conference?
She did. If you just go down the page, you can see a reference to Ms McLeod below Mr Hanks. Again, this is for context and only to highlight that it was a matter of interest, not only at Chief Counsel level, but at secretarial level at DHS.
Yes.
Right.
Sorry, can I just pause to read the part under? Thanks, Maurice.
Yes, of course.
Righto.
You can see, of course, that Ms Golightly asked the question whether it was worth a call to the Ombudsman to find out what they might be saying and impress on them that further negativity or discussion beyond their public report might not be helpful to anyone.
Yes.
My interpretation of that would be that there was an attempt to reduce public statements by the Ombudsman about any further scrutiny of the scheme.
Well, at least to understand whether that such statements might be imminent, but...
Yes. We turn then to tab 12, Exhibit 4832.
Yes.
You can get a sense of the mood within DHS about the topics to be covered in the conference.
Yes.
I should indicate also, for completeness and context, that tab 10, Exhibit 4830, there is the reference to potentially 8 lawyers from DHS attending and 3 SES officers.
They had a lot of lawyers.
The program is Exhibit 4140 behind tab 13. You'll see on the second page the plenary session 3 is the National Lecture on Administrative Law, and that's the one presented by Mr Hanks. A relatively prominent speech delivered during the course of the conference.
Yes.
And I will take you to tab 16, Exhibit 4141. These are the updates which were referred to in the earlier email that Ms Mussolino asked to be conveyed to her as she couldn't attend. They sent as you can see the timestamps on the email messages, they're sent as the lecture unfolds. And at 5:56, the main thrust is the suggestion that raising of debts using averaging is not consistent with the terms of the Social Security law. Further, that the law provides no scope to put the onus on the customer to provide information that they do not owe a debt. Then there is a series of further updates which conclude or complete points thought sufficient to update the Chief Counsel. And if you go to the next tab, 17, Exhibit 4833, you will see an email from Ms Mussolino to the Secretary, that's Ms Campbell, which reproduces the summary of criticisms that were sent during the course of Mr Hank's lecture to Ms Mussolino in the previous document.
Yes.
And Ms Mussolino says, update on the AIAL conference. Peter Hanks QC spoke at today's conference. His speech was extremely critical of the OCI program. The key criticisms are summarised below. None of the criticisms are new. However, noting that the organisations such as ACOS and Legal Aid were present, the comments may end up in a press release or in the media. And you can see Ms Campbell's notation in the top corner, noted, thanks, Kay Campbell, 24 July 17.
Yes.
Now, it's 3:30 and ordinarily a break's taken then. I'm going to move on to the document behind tab 15, which is the reproduction of Mr Hank's lecture in the AIAL journal, which was published in October 2017.
Okay.
Thank you.
5 minutes. Thanks.
All rise. The Commission stands adjourned for a short break. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. If you've had the opportunity just during that very short break to flick through the print version of the paper, you will see that Mr Hanks identified...
Commissioner, sorry, just before the witness continues, I just note his senior counsel is not present.
Oh, I dare say he'll turn up.
Just in case he's caught up.
Mr Perry, do we need him?
I'm happy with my junior counsel, if you want to proceed.
Perhaps proceed? All right, thank you.
Mr Porter, if you had the opportunity to flick through it, you would have identified that Mr Hanks was critical of the underlying assumption that the onus lay on a social security recipient to prove that the income was not correct, that is the PAYG summary was not correct, and that the concept of averaged income did not provide evidence of fortnightly income in short compass. Now, I appreciate you haven't digested the document in any detail, but those points were at least present in very short form in the summaries provided by persons there to Ms Musolino, then to the Secretary. Do you consider that the paper, that is the opinion at this conference, in the context of the criticism of the scheme, including the Ombudsman's investigation, the Senate inquiry, the media, the defence of the scheme that was undertaken, as you've described your role in, based on the talking points, and the blurry line between the division of responsibility for legislative adherence, that where this occurred, it ought to have been brought to at least Mr Tudge's attention by his secretary then, or even to your attention?
I think that's a fair proposition. The thing I'd add to that is that having gone through this process for the Commission and having reviewed a great many documents, the internal traffic that appears to occur inside DHS in that post-January 10 period on the issue of legislative underpinnings is another point that I would add to that list, which tips the scales that a paper like this warranted some further and better consideration.
And it appears, at least on the documents I've taken you to be brought to the Secretary's attention, who noted the brief summary that was sent to her by her Chief Counsel, and nothing comes of it. Do you recall anything that came of it, or whether it was drawn to your attention in any way?
I don't recall the conference or the article. I don't recall it being brought to my attention.
Can I take you to
Just on your answer before, though, one possibility was it be drawn to Mr Tudge's attention. Do you think it warranted being drawn to the Social Services Minister's attention as well?
Well,
given that they have responsibility for the Act?
I think the short answer is yes, I would have liked to have seen it. And it wouldn't have been necessarily unusual for a paper like this to be sent up under the form of one of those noting briefs or something of that nature. But frankly, a risk with a paper like this in a busy ministerial office, if the paper just came up under a noting brief, I might get through the third paragraph and read language like scapegoat and think, oh, well, another paper criticising the government. But if it came up in the context of a brief that said, this raises an issue, we've considered the issue, and there was some due diligence done by the department around the paper and it got sent up that way, I think it would have caught the attention of a minister.
I I want to move forward now, remaining on the topic of legality, to 14 August 2018. Now, by this point, you are the attorney.
Yes.
Left, the role as DSS Minister in December 2017.
Yes.
Well, in fact, before I go there, of course, Ms Campbell replaced Mr Pratt in September 2017, shortly before you left to become the attorney.
Yes.
And you've seen from the document I took you to her awareness of the criticism by Mr Hanks at a fundamental legal level in the email from Ms Musolino.
I've seen her signature on the document, yes.
Yes. Do you consider that when she became DSS Secretary, the obligation to inform you of that paper being delivered, noting it was published in October 2017, a month or two after she came over and a month or two before you left, you consider that there was an obligation on her to draw your attention to that question?
As Attorney General?
No, while you were still DSS Minister, late 2017, after she came over.
Well, I think, consistent with my previous answer, I would have liked to have seen that paper.
And it would have easily caught your attention if she had said to you, as your secretary, we had 8 lawyers and 3 SES staff attend a conference in July. The paper's now been published. It identifies a fundamental legal question. Would you like to consider it?
I wouldn't have expected that an article like this would just come up on a bare noting brief. I would expect it to come up with some analysis. We think the arguments raised are strong or weak. We think the better view is this or that. But I would have expected that if it had come up, it would be accompanied by some interrogation and views from the department.
Just on that point, that it would have come up even if the analysis of it was that the arguments were weak?
Well, I think in this context,
yes.
Yes.
Tab 29, Exhibit 4190. The date of the email is 14 August 2018. You, of course, are no longer the Minister for Social Services, but it continues the theme of what you might expect from your experience as a Minister in the portfolio. And there is an email from Clayton Utes to Ms Fredericks, who was then a lawyer within DSS. At the time of the AIAL conference a year earlier, she was a lawyer in DHS, which attended the Hanks lecture. In the meantime, a decision of the AAT had been made which found that the process of averaging was not a valid basis to raise a debt. And
when you say meantime, whenabouts was that AAT decision?
Early 2018.
Right.
Again, after you had
yes.
moved from the department. And in the context of the consideration about whether DSS would appeal the decision to the second tier of AAT, an advice was obtained from Clayton Utes about the legality of averaging. The advice is tab 30.
Yes.
Exhibit 4191.
Okay, and that's unsigned and in draft, is that?
That's in draft, yes. You know, if I take you to page .0111, page 8 in the bottom right corner, you'll see that the persons who are designated as authors to the advice include Mr Sibley, who was, from the earlier email, the current AIAL president at the time, Mr Hanks, delivered his paper. The conclusions expressed by the authors to the draft advice was that, as you can see at paragraphs 6.3 and 6.4, it was not open to the department to conduct a national assessment of persons' income in respect of particular fortnightly periods in the manner proposed. The Act presently requires evidence of actual income paid to a person in respect of a fortnightly period to be assessed. That is, the opinion was that it was not a valid decision-making process to raise a debt by reference to averaged income. Now, the evidence the Commission has heard is that the advice was not sought in final form, and it bounced around, it seems, inside the DSS legal department and went nowhere. Do you consider that your successor, Mr Tian, ought to have been informed of this advice irrespective of whether it was in draft or final form?
Yes.
And are you aware of the practice of not asking for adverse advice to be converted from draft to final?
Well, I'm aware that such things have occurred in the history of the law, but that it was engaged in by this department at this time, no.
Right. Can I take you to tab 31, as it is Exhibit 4146. The email, second from the bottom, that is the one that was sent after receipt of the advice on 14 August 2018, indicates an awareness of the significance of the draft advice to the OCI scheme, or EIC as it had become. Can you, in your experience as a Minister for DHS and then in your experience as a Minister, as the Attorney-General, comprehend any circumstances in which that awareness of the significance of the advice would not be escalated to at least the Secretary level, Ms Campbell, or to the Minister?
No, and from the very brief reading I've had the advice, it is something more than somewhat unhelpful, I would say.
Yes. During the first half of 2017,
Yes.
do you recall meeting with or talking to the Prime Minister, with or without Minister Tudge,
Yes.
in respect of criticisms of the scheme, that general topic?
Yes, I recall multiple communications with then Prime Minister Malcolm Turnbull about the scheme and the criticism it was coming under in early January. I can't be absolutely precise about when they were, but I recall broadly oral communication, probably telephone, at the end of that period or shortly after the end of that period of acting. I think that then there was a meeting once Minister Tudge returned from leave and we'd gone through a handover of the problems that had arisen and so forth. I think that meeting was with both Minister Tudge, myself and the then Prime Minister. There may have been others there, but I can't recall who.
Do you recall what was said in general terms to the Prime Minister about the scheme?
In general terms, the tenor of those meetings was that both Minister Tudge and I considered that the scheme had a number of inherent procedural flaws and unfairnesses, that its fundamental and initial design could have quite simply avoided those, that the view that we shared was that they could be repaired and fixed in short order. I think I
I think I did put the view that that will require significant pausing and cessation of the process for some, if not most, cohorts of recipients. And by this stage, we'd managed to disaggregate the groups of people that were receiving these letters and identify where the risk was highest of processes being inappropriate for those groups. And so the concept was that you'd push out groups where the process might be inappropriate until you could fix the process. So it was both a view about the procedural problems, their fixability, and early warning about the fact that this would have a significant impact on the savings that the scheme would garner.
Do you recall that PricewaterhouseCoopers PwC was engaged by DHS to review aspects of the scheme?
I don't specifically recall that, no.
I take it you don't recall being provided with any information about what their review indicated?
I can't exclude the possibility, but I don't recall it.
Do you recall whether Minister Tudge ever spoke to you about suicides associated with the scheme?
I don't recall ever having that conversation with Minister Tudge. I do recall at a later point in time that being an issue of media attention in at least one case, but I don't recall the details of it.
When that occurred, did you consider that that was a matter which was appropriately dealt with by Minister Tudge or by yourself?
I was of the view that they were about the operation of the scheme and that wasn't something that my office and I were attending to.
Consistent with the division of implementation as opposed to policy development in the two departments? Two final topics, Mr Porter. The first is the question of the garnishee measure for people under arrangements.
Yes.
Payment arrangements. And the second is the recovery fee.
Yes.
Dealing with the first, tab 143 in volume 2, exhibit 4939.
Yes.
You recognise this as a brief to you in respect of the question of the decision to suspend garnishees across the board because they included persons who were under repayment arrangement with the department. I will first ask you, and I don't mean to be critical, to read your handwritten notes into the records so there's no ambiguity.
Well, I might ask you if we can enlarge the screen so I have at least some prospect of doing that. But
the bottom half of the screen could be pulled out, please.
Thank you. Thank you. So suspension of non-SS Act debt tax garnishee to be maintained until 1 March 2017. Legal advice to be obtained with respect to section 1230C, subsection 3, notably the applicability of applying the Secretary's discretion to a subset within the cohort of those with a debt and in an arrangement and with a substantial tax return amount relative to debt. 3, suspension of SSA Act debt tax garnishee for those in arrangement to be maintained until I've considered advice requested in 2 above.
You were informed, as the note sets out, that it was considered, it seems by DHS and DSS, that the garnishee measure applicable to persons who were in a payment arrangement was unlawful and they had been suspended because of that belief.
Yeah, now that it's repeated, I recall that was the issue, yes.
Your reference to the section in the Act Does that reflect that you reviewed the legislation and had a look for yourself what was being referred to?
I couldn't say for sure. I may have picked that up from some alternative source rather than going to the source of the legislation, but I was aware of the linkage between the provision and the issue.
The minute continued based upon the conclusion of unlawfulness over the page in paragraphs 3, 4, 5 and 6, that there were some limited options which could be taken, and 6 referred to the question of legislative change to enable full implementation of tax garnishes as a measure, not of last resort, but at an earlier stage in the debt recovery process. Now, this occurred, I think, if we look to page 3, your signature appears, the signature of Ms Halbert appears as 17 January 17, and your signature at the bottom of page 1's 25 January 2017. Next tab is tab 159, exhibit 4951. The briefing minute, exhibit 4951, dealt with both the status on interest charge updates, recovery fee, as well as the tax garnishee. But you can see on page 2 at paragraph 6 under the subheading tax garnishee, it appears as though your notations have been reproduced. That is your notations on the previous brief.
Yes.
Not precisely, but...
They're trying to give effect to them.
Yes. Yeah. And at paragraph 8, it's identified that the legal advice you requested is at attachment B, and in summary, the advice indicates the Secretary may decide under section 1230 capital C sub 3 of the Act that the recovery of a debt by repayment arrangement is not appropriate based on information such as the presence of a tax return. And it continues. The advice itself is a number of pages over, ending .3523, that's attachment B. The way in which it's written suggests that all the lawyers in the department had overlooked the question that you were asking in terms of the lawfulness of the question. And provided a response which might be considered to be favourable in respect of the question that you asked. There isn't much analysis in the advice, would you agree, in respect of text and context, the usual approach that one might take to the scope of the exercise of a discretion within administrative law parameters.
Well, it's not in the form that sometimes we'd be familiar with.
Yes.
14-page advice and the better view is, and it doesn't take that form.
No. but at least it came from or with the stamp of approval of the Chief Legal Counsel, Ms Janine Richards.
Yes.
And Ms Pulford is also referred to there on the last page. Can you recall, following this advice, whether the decision was made to resume the tax garnishee for people under arrangement, or whether the original view prevailed?
I can't. I mean, I recall the issue. I'd be speculating as to what the result was.
The final topic is, of course, the recovery fee.
Yes.
What's your recollection of the circumstances in which that arose and advice was sought?
Very broadly, the recovery fee, once this period in early January had finished, the handover had happened with Minister Tudge. Minister Tudge was engaged in efforts to fix the procedural problems that are clear, and there was a concern, it was my concern, I think it was shared by Minister Tudge, that there be a pausing and a slowing down, that there'd be time to reorganise and fix the processes. The recovery fee was being applied to everyone, and I recall that the issue was trying to ascertain whether or not the recovery fee could not be applied to those people for whom a debt had been issued under the OCI system.
The advice that you were given is also contained in this same document, it seems, because it dealt with 3 points. You go back to the second page of it, there's an online compliance and recovery fee subheading.
Sorry, tab,
159.
yes.
The second page of the brief.
Yes.
In the bottom half, online compliance and recovery fee.
Yes.
And what was said to you there by way of advice was, under the Social Security law, a 10% recovery fee will apply to a debt where a debtor refused or failed to provide information about their income unless the Secretary or his delegate is satisfied the debtor had a reasonable excuse. There are a couple of words left out of that short summary which are contained in the Act, and they relate to a person being under an obligation to provide the information, and in that context, refusing or failing to provide the information. Again, do you recall generally whether you were satisfied with the extent of legal advice that you were receiving on the topic? In the context, I should give you...
I see what...
Yes, you see where I'm going, that where someone is being asked in an online environment to confirm or update information from years earlier when they were under an obligation in a fortnightly period to provide information to obtain a benefit or to satisfy the threshold for the benefit, how the obligation could be said to arise in the context years later by a request for information.
So, Counsel, you're putting the point that I've asked a question here as to whether or not we could waive the 10% recovery fee for this group.
Yes.
And had there been closer consideration of that question, a secondary question might arise as to whether or not the group had ever properly been under an obligation to provide the information, so the 10% recovery fee might have not applied to any of them.
Primary question, perhaps.
Right. Yes, the other way round, because the online compliance program...
I understand the point.
...assumed an obligation existed at that point in time where someone didn't update or provide information and a recovery fees applying it.
It wasn't the question that was in my mind. If you're putting the proposition that we were close to discovering something further had this been pursued, then I would accept that that's the case, as there were many points in this process where I look back on it and think I was getting close to piercing the veil of some of these issues, but never quite got there.
Okay. On that penalty fee, I think there were two schools of thought in the department, or in DSS at any rate. One was that there must have been some obligation in these notices, but plainly they weren't notices under the Act. The other was that if somebody had an averaging debt raised against them, they must have done something wrong in the first place, must not have disclosed back at the time they were receiving the benefit. But given that averaging was hit and miss, you couldn't assume that either. So on either basis, there were serious problems with this penalty, but it doesn't seem anybody ever thought about it.
No, and I will confess I didn't think of those two approaches. My primary concern was to find a way, knowing that the Secretary had a discretion, to find a way to lawfully enliven that discretion so that it wouldn't be applied to this group of people while we tried to fix the system.
You don't seem to have approached any of this from a lawyer's point of view, really, do you? You don't seem to have at any stage said, well, by what authority do we send the letters, or by what authority do we average, or by what authority do we impose a penalty?
Well, I'm obviously legally trained and I'm a lawyer, and I bring that to working in a portfolio, but the environment's completely different, and pausing at every point to question the basis of every action or omission that was being administratively undertaken is just not a process that you went generally through. And I appreciate that in these circumstances there was controversy around it, but there were many controversial programs. I can say, Commissioner, had some of the correspondence that I've now seen, or some of the doubts that existed in the department, been raised with me, in all likelihood that extra step would have been taken. But
did you see Mr. Martin's article in January? Peter Martin, he wrote an article dealing with averaging. It was drawn to Mr. Tudge's attention by the Prime Minister. What about you?
January of what year?
2017.
I don't recall. If I can have a look at the article, I might be able to assist.
I think it's in Mr. Tudge's material. I'm not sure
is.
it's in Mr. Porter's. Can we turn it up?
I don't have ready recourse to it.
And I think in proper answer to your question, Commissioner, I've approached this, I considered the time in a more lawyerly way than most ministers would, but I wasn't operating as a lawyer, and the department had teams of lawyers. And for a very small office like the one that I was operating, to be going back to base statutory provisions on the broad range of matters that were coming up to us just wasn't a process that we engaged in.
This was a program that was affecting literally hundreds of thousands of people. Well, I suppose by the end of December it had affected probably 100,000 people. I think 90,000 notices rolled out in that last quarter, or maybe more. And clearly, from the media, it was affecting people badly. People were getting notices just before Christmas. There was a story about somebody who had killed themselves and so on. Given that you weren't clear on this averaging business, it doesn't seem, did it not occur to you that maybe a root and branch review of this to make sure it was sound in every way was needed?
Well, I think I got close to that point when I've inquired about the legislative underpinnings in January, and I was very assured at that point in time, by my knowledge of how these processes came to be, that it must have gone through this kind of checklisting process about the statutory underpinnings. I made an effort to reassure myself about that process in these meetings. Had the response been different, had I seen other things, I may have well gone down the path that you're describing, but I didn't.
But with that answer about statutory underpinnings, there are a lot of facets to this program. There was the data matching, there was the sending out of the letters, there was the possibility of averaging in some circumstances. So how could you be very confident about an answer that just said, yes, there's the statutory underpinnings there, without exploring a bit more what there was an underpinning for.
You placed enormous faith at first instance in the advice that you were given. When advice was given with confidence and certainty and was unequivocal, the prospect of you necessarily investigating that further would be much lower than when someone from your department expressed doubt or equivocation on these issues. I can't explain it these years later any better than that.
Were you exploring it with Mr. Pratt?
No.
Why not? He's your secretary.
Yes, but he, it appeared to me, came into that period as cold as I did in terms of foreknowledge of it. And this was not an area, because DSS had not been involved in the design, that the upper echelons of that department were very helpful. I mean, in that period in January and after, really, myself and obviously Minister Tudge were relying on information from DHS.
What about Serena Wilson? She did know a bit about the proposal. Did you have interaction with her about how this had all come about?
I know through the Commission's process, excuse me, Commissioner, that Serena Wilson, it appears, was aware of the advice that cast doubt on the legislative underpinnings. I heard that through the Commission process. I was involved in any number of meetings with Serena Wilson. She always struck me as a very good public servant, but it was never brought to my attention. Had it been, then my mindset about this would have been quite different.
Yes, well, and she certainly didn't suggest that she had done so. But I'm just interested in the level of discussion you were having with your own officers about what was going on with what we now call the Robodebt scheme. Because you see, Mr. Porter, everybody says it was really somebody else's doing, and it's a bit hard to get to the bottom of whose doing it was. And any light you can shed would be helpful.
Well, there are certain critical points and gatekeeping points around this, and there's no doubt that period in January where I was heavily involved was one of those. I don't dispute that at all. The creation of the policy is probably the most important point in that respect. But the failure to penetrate through that fundamental question that the Solicitor General addressed, and it occurred most critically at different points in time where that question was most likely to be asked and addressed. But had information that I've seen come through the Commission been available in 2017, then I think that authoritative advice from outside would have been sought 2 years earlier than it was.
You take any responsibility for this?
I do, and I look back on this and I see myself through the correspondence getting quite close at points to taking the next step of inquiry, and I didn't do that. I wish now that I had, but I also see the reasons why I didn't do that.
I think the Martin article's available if you want a quick look at it and see if it rings any bells.
I don't readily recall it, but it may well have come across my radar, but I wouldn't have viewed this in the same level of, as a document of the same level of authority, say, for instance, as Mr Hanks' piece or...
All right, and you didn't in the course of 2017 ever say, what's the AAT saying about this?
So my recollections about the interrogation of AAT decisions is that the first time that my office or I started to go through those decisions was as Attorney General, and either around the point that the questions were being put to the Solicitor General for his advice, Commissioner, or after, I recall my office going back and looking at AAT decisions, and there were decisions that were clearly negative in terms of saying there was no basis. There were decisions that allowed debt to be paid on that basis. But the first time that I had those brought to my attention was as Attorney General in the context of seeking or receiving the Solicitor General's advice. I don't recall having those AAT decisions elevated up to me as Social Services Minister.
All right. I think that's all for me. Did you have anything arising out of that before I...
One question. Mr Porter, you referred to meetings with Ms Wilson with a degree of regularity. Does that include the period January, February 2017?
I think that she was involved in those meetings, but I couldn't say with certainty. But Serena Wilson was also heavily engaged in our welfare integrity reform process, and my recollection is that her background was in DHS or Centrelink, and she was very knowledgeable about processes, payments, categories of payments, criteria and so forth. So there was a reliance on her expertise.
What about Catherine Campbell? Sorry, I said I'd finished asking questions, but I haven't. How much were you having to do with her in this period in January 2017? I appreciate she wasn't your secretary, but you seem to have been looking to DHS for answers.
Catherine Campbell was certainly involved, and particularly at the end of that period, my recollection, the sort of 7 to 15 January period where my period of acting is ending and we're handing over to Alan, and we've sort of consolidated all of the problems, provided the department with directions as to how to fix them, that Catherine Campbell was heavily involved during that period at least.
And were you getting any assurance from her about the scheme in respect other than how it was going to be fixed? In other words, you talked about somebody telling you that the thing had sound legislative underpinnings. Did you get any assurance from her like that?
I can't recall who was providing the affirmation to that exchange, and I would be totally speculating. I cannot recall, but I recall the exchange. It was incidental to the problems that we were dealing with. It occurred to me to be the right question to ask as an extra safety point about the checklisting that I knew would have occurred during an MPP. But I can't recall in what meeting or who it was.
Mm-hmm.
For completeness, I just wish to identify the document that was shown to Mr Porter by reference at least to the document.
Thanks.
RBD.9999.0001.0369. Thank you.
Anything, Ms Hogan?
That's Exhibit 4321.
Thank you. Mr Moses.
No questions from me, Commissioner, but if Mr Porter could be excused.
All right.
Yes, thank you, Commissioner.
Thanks.
Commissioner, might I just have it recorded for the benefit of the transcript? There's no questions from the Commonwealth.
Thank you. Thanks, Mr Porter. You're excused.
And Commissioner, may we be excused as well?
Oh, thanks, Mr Moses, yes.
Commissioner, the next witness is Ms Janine Richards.
Do you want a short break or...?
I think so, yes, but just before we do, can I clarify one matter of housekeeping? I'm instructed that on the exhibit list there are asterisks against some exhibit numbers. I place on the record that asterisk denotes that the document is tendered for a limited purpose, which is understood between the Commonwealth and...
Thank you, they're nodding.
Thank you.
All right, I'll just break until I'm told that the witness is ready to go.
Thank you, Commissioner.
All rise. The Commission stands adjourned for a short break. The Royal Commission is now in session. Please be seated.
Mr Gregory.
Commissioner, the next witness is Ms Janine Richards.
Yes, Ms Richards, will you take an oath or an affirmation?
Affirmation, please, Commissioner.
Okay, could you stand?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? Your response is, I do.
I do.
I'll take a seat, thanks. Yes, Mr Gregory.
Thank you. Ms Richards, can you tell the Commission your full name, please?
My name's Janine Richards.
And you were served with a notice to give a statement and produce documents NTG-0141 dated 21 December 2022 and produced a statement in response dated 18 January 2023. Is that right?
Yes, it is.
Thank you. Ms Richards, in 2017, what was your role?
In 2017, I was the Group Manager for Corporate in the Department of Social Services.
Was that a legal position?
It was a combined position because I had the Chief General Counsel title as well as the Group Manager title for Corporate Services.
Does that mean that you, did you say General Counsel?
I think it was
Or Chief
Legal Counsel.
Chief Legal Counsel.
I've occupied a few of those positions, sorry, and
Does that mean that you were the top of the legal tree within DSS in that role?
It meant that I was the most senior lawyer in the hierarchy of the department.
Thank you. A much better way to put it. Was your counterpart in the Department of Human Services Annette Musolino?
To the extent that my position was responsible for legal services, yes.
Right.
But I had other counterparts, bearing in mind that I had other responsibilities.
Certainly. My question is focused upon the legal aspect of your role and the balance of them are as well. How often would you meet with Ms Musolino in respect of legal issues, that is the legal aspect of your role?
We had an arrangement where we met informally on a monthly basis. So I would usually go to the Department of Human Services at first thing in the morning and have a meeting with Annette and would cover a range of issues. And I would take Alan Grenzel-Jones with me.
And where did Mr Grenzel-Jones fit in the hierarchy you described?
Alan Grenzel-Jones was the branch manager for the Legal Services branch.
That is a completely legal role?
Completely.
The public law branch is a phrase that the Commission has heard. Is that interchangeable in terms of a title?
I'm not sure that it was called the public law branch in 2017, but in the period that I was referring to, and I was the group manager for corporate, I think it was called Legal Services branch.
Right. If I could have Exhibit 112 brought up on the screen. Ms Richards, there is a hard copy bundle of documents before you and it should appear as behind tab 6. You will recall that in early 2017, the Ombudsman initiated its own motion investigation into the online compliance intervention program implemented by the Department of Human Services.
I do.
And as part of that investigation, the Ombudsman sent letters to your knowledge to the Secretary of the Department of Social Services informing him of the initiation of that investigation and an inclusive list of topics that might be addressed.
That might have been the case. I don't recall that though. No.
It appears that you had some involvement in the department's response and your name appears in this document. The first email in the sequence over on the second page, .3406, is from Ms McLeod, who at that time was an acting senior assistant ombudsman.
Yes.
And it referred to a notice which had been issued under the Act and sought information from the Department of Social Services in respect of advice from DSS about legislative change that would be needed for the program, and any other notes, documents or emails that relate to that advice. You are first mentioned at the top of that page in the short way in an email from Ms Halbert to you, 27 February 2017 in the afternoon, and it simply says, Janine, as discussed, I will call you about it this morning. You can see that? Yes. Sorry, just above the pulled out part. I'm going to take you back to that point in time and ask you to describe to the Commission your recollections of your involvement at that point in time.
Well, as I indicated in my statement, I don't have any recollection of the conversation that occurred with Kath Halbert at that time. And this part of this document is attached to my statement, which reflects that I had received that email from Kath. I was indicating that I was going to be occupied in Parliament House the following morning, and I tasked Alan Tudge, who, as I said, was the branch manager of the Legal Services branch, with responding and assisting Kath to identify the documents that the Ombudsman had requested.
Do I take it from your email at the bottom of the first page of the trail, .3405, that the extent of your recollection now is recorded there?
Yes, it really is. I couldn't recall when I received the notice much in the way of involvement with the Ombudsman's investigation at all, on a personal level.
And does that email that you sent to Mr Grinzel-Jones indicate that in the conversation with Ms Halbert, you understood that the someone referred to they were looking for advice that bridges or explains why our approach has changed from the view that legislative change was required to the view that it wasn't?
Well, attached to the email that I received from Kath Halbert was a copy of a minute that had been prepared by the Department of Human Services for the then Minister for Social Services. And it was that advice that the Ombudsman was referring to that had been referenced in that document. I wasn't familiar with that advice. I hadn't provided it. But the custodians of those records were really in the Legal Services branch, which was why I tasked Alan with identifying what the Ombudsman was after.
Do you recall whether you gained any impression from Ms Halbert that she was involved in the advice referred to in the executive minute?
No, I can't recall that.
No, all right. Is it the case that the reference to the they that is referred to in this email, is that a reference to the Ombudsman or is it a reference to Ms Halbert or her group?
Sorry, can you just clarify which they you're referring to in the email?
The start of the second line. I spoke to her quickly last night and they're looking for advice. Yes.
So that would be referring to Kath Halbert's group. So they would have been recipients of the advice, so they would have been the other custodians in the department that would have had the advice that was being requested.
Okay. I may be at cross purposes with you, or I might just not understand how things work in the department. If Ms Halbert's group was the other part of the custodians of the advice, why would she be asking you for a copy of it?
Well, I think it'd probably be prudent for her to do so if you receive a request from the Ombudsman. So the Legal Services branch had provided advice. Her group had been the recipient of the advice. If you want to make sure that you're providing a comprehensive response to the Ombudsman, you'd check both locations to identify any advice that needed to be part of the response.
Okay. Did you get any impression to your recollection that Ms Halbert had a copy of the advice and was looking for something more?
I couldn't say. I don't recall.
Right.
Yes, they're looking for advice that explains. Did you understand that to mean they wanted an advice to come into being?
No, Commissioner. I understood that we were looking for records that had been referred to in the minute that DHS had provided to the Minister for Social Services. So I understood that the Ombudsman was asking for advice that already existed and that was what we were looking for.
Okay.
What was clear from the minute was that advice had been given that legislative change was required to implement the proposed measure. I might take you to the document.
Yeah,
if
let's
you're
do that.
uncertain about
Yes,
it.
yeah.
Exhibit 2015.
Which of my attachments would that
I
be?
don't think it will be in your bundle. I think that's the issue. DSS.8.001.001.340_R. This might just take a moment, Ms. Richards. And my recollection is it's page 10 of 17. Yes. The last dot point, if that could be called out.
Yes.
Yes. Does that refresh your memory about what the Ombudsman was referring to?
Yes, it does. That was what the Ombudsman was referring to.
Thank you. And so, in terms of your email, where you say, from the view that legislative change was required, that is a reference to what appears there on the screen. I know.
Yes, sorry, yes it is.
Thank you. And the second part of that sentence, to the view that it wasn't, where did you get that information from?
I suspect that that was based on my conversation with Kath Halbert, but as I said, I don't really recall the specifics of that discussion.
To be clear, did you have any involvement in the advice back in that is referred to in the called out passage of the executive minute?
No, not that I could recall, and not that I could locate on my search of the records in preparation of my statement.
Do you recall that issue coming up about whether smoothing could be done within the bounds of the Social Security Act?
No, I don't.
Smoothing, averaging.
Yeah, sorry, Commissioner, certainly not in 2014. I don't have any recollection of becoming aware of the issues probably until about January 2017.
Right. And did you expect there would somewhere be an advice that explained why the approach changed?
Well, on its face, I just took the minute at face value that the Department of Human Services had given advice to a minister that they had received advice from DSS that legislation was going to be required, and that the Ombudsman was then looking for advice to suggest otherwise.
Mm. And did you think it existed, or did you have any idea? Did you get any?
I didn't know. I mean, so the query was to go away and see what advice could be identified. We maintained a legal advice database, and so my expectation was that the databases would be searched to the extent that it was necessary to do so to identify the advice that was referred to.
Thank you.
How sophisticated is the categorisation in the legal advice database?
Not particularly.
Okay.
It was built probably on the smell of an oily rag in a SharePoint system. But it did give us the ability to both catalogue and retain advices and cross-reference them to our matter management system that was called Lex. So it gave us, probably compared to what had been predecessor processes within the department, much greater reliability and searchability about material and advice that we'd either provided previously or procured. So it was internal and external.
Okay. At the top of the email trail, back in Exhibit 112, behind tab 6, you'll see a reference to Ms. Pulford, her name appearing there. Do you know Ms. Pulford?
Yes, I do.
How long have you known Ms Pulford for?
I would have known Ms Pulford since I commenced in the Department of Social Services in early 2013.
Your last contact with her in the department? How long ago was that?
Well, it would have been when I left the department in June of 2018, so it's been some time since I've had contact with Anne.
Do you have any recollection of discussing this question with her at any point in time?
No, I don't.
You referred to before I complete the topic, after passing it off to Mr Grinsell-Jones, did you follow up with him or with Ms Halbert about the resolution of the issue?
I didn't follow up with him, but I didn't hear back from him to suggest that there'd been a problem identifying the advice, so it didn't seem necessary to do so.
Oh, sorry, I just misheard.
Sorry, I did not. I have found no record of following up with him, certainly, and I have no recollection of following up with him. But I would have expected if there had been a difficulty identifying the advice that they would have escalated that back to me.
Oh, you didn't hear from him that there was a problem?
No.
I understand. Did you take any particular interest in the Ombudsman's report when it was finally released?
I think, as I've indicated in my statement, I received a copy of the Ombudsman's report, but it was really wearing my corporate services group manager hat. It was sent to me by the branch manager for the communications branch, indicating that they were working on talking points for the then Minister for Social Services to the extent that they would have been required. I couldn't find in my search of the records, though, being copied on anything from them in relation to whatever talking points would have been prepared for the Minister.
One of the issues which has risen in the Commission is the question of the provision of draft advice, external advice obtained in draft and not finalised. One example of particular relevance to the Commission was an advice in respect of the lawfulness of averaging as a basis to raise debts, which was obtained in August 2018 by the legal branch. The persons involved were Ms Pulford, Ms Fredericks, Ms Lumley, and up it went. Are you aware of that advice now?
Well, I don't have personal awareness of it because I left the department in about June of 2018, so I think this occurred after my departure, if that date is correct.
Yes, but are you aware of it in terms of your awareness of what the Commission has identified?
I'm aware of it generally, but I haven't been watching the detailed progress of the Commission.
That's okay.
It was certainly raised in a conversation with Council.
Yes, all right.
Yeah.
What can you say about the practice of obtaining advice in draft and not converting it to final from your time in the department as Chief Legal Counsel?
I'd say it was not uncommon to get advice in draft from an external counsel, and it wasn't necessarily uncommon for internal lawyers to provide advice in draft. And that was frequently because the social security law is actually pretty big and pretty complex and has a complex legislative history. And the instructions that we received were frequently reasonably abstract. They weren't here as a brief of evidence and facts that are reasonably establishable. It was a bit fuzzier than that. So we would provide a draft of advice, or we would obtain a draft of advice if it was necessary to make sure that we understood the issues that we were being asked to address. And it was certainly the case, probably more so with external counsel from time to time, that they would want to put advice in draft to make sure that they understood what we and or our clients were asking of them, that the issues were clear before they finalised it.
Before they finalised it, the assumption is that they finalise it.
I would say that the assumption was always that it would be finalised, Commissioner.
Mm-hmm.
That is, once there is confirmation that the factual basis upon which the questions were asked and there was confirmation of the nature of the question which was asked, it would be converted to final.
Yeah, my expectation was that an account would invariably not be paid to external lawyers until their advice had been, or their final account wouldn't be paid. So usually if I had received advice in draft for any reason and we'd settled with the internal client, that they were satisfied that we understood the issues, that we were providing an answer to the question that they were asking us, then I would ask external counsel to finalise their advice and send me their final bill.
Clayton Utes was on the panel of external advice providers during your time. The process.
Yes, I think they have been on various Commonwealth panels, and all what we had then was probably the multi-use list, so they would have been commonly providing advice to the common.
And familiar with the process you've just described, where a draft is provided, confirmation about those questions is provided or taken, and then the advice is converted to final, and then the invoice is paid.
I don't know that I could say that what Clayton Utes at that time were familiar with in terms of our processes, because bearing in mind the Department of Social Services, its external legal spend was more significantly directed towards the Australian Government solicitor than to other external lawyers, and that tended to be because as a policy department, a lot of the advice that we needed to obtain on things like constitutional risk assessments was tied to the Australian Government solicitor. So it wasn't like a high volume litigation practice where you had established procedures that were necessarily followed with external counsel, or that you could say that they would be familiar with.
The advice received here, and I appreciate you left the month before, was adverse to the legality of the OCI scheme, or by then EIC or CUPI scheme, but a significant government scheme. Can you contemplate, in wearing your general counsel hat, circumstances in which that would not be brought to the attention of the head of the legal branch, Mr. Grinsell Jones?
I'd find that difficult to believe that it wouldn't be brought to the attention of the branch manager for legal services, yes.
The client, as it were, in this case was one of the policy areas in the department, who engaged and gave approval for the expenditure on an external advice.
Yeah.
In that context, do they own the advice within the department? Can they control where it goes and who is seen by it, or are the lawyers in the legal branch able to disseminate it according to their obligations?
So in my time in the department, it would have been the expectation that it was departmentally acquired legal advice that wasn't owned by any particular part of the department. Yes, the issue around legal services budget might from time to time be used as a sort of, if we're paying for it, it's ours issue, but we really mitigated against that from the perspective of the independence of the in-house legal practice.
So there are two routes then whereby the advice might be drawn to the attention of the Secretary and then the Minister, either through the hierarchy of which you were at the top of, assuming you were still there, that is the legal counsel section, or through the client area, the policy area, through the Deputy Secretary in charge of that area.
I mean, bearing in mind that this occurred after I left the department, it requires me to be speculating a bit about what might have happened.
Yes. But on the question of an advice which was significant in terms of publicity, adverse publicity, which was present at the time you were there, affected many people and was related to the lawfulness of raising debts, would it be your expectation that there ought be no hesitation in both the legal branch and the policy branch, which commissioned the advice, working together to send that all the way to the top of the department?
I think it probably would have been the preference of the policy branch to send it to the Secretary.
Right.
Yeah.
And why do you say that?
Well, because they would have been providing advice to the Secretary generally on the substantive issues around the policy questions, which included legal but other issues as well. So they would have been providing a sort of consolidated, advice to the Secretary, whereas the Legal Services branch was only looking at discrete issues at their request.
Does that, to your mind, create the potential for gaps where the Legal Services branch would consider that they might be engaged in only a confined part of the process and it was otherwise the policy area or whoever the client may be who bore the responsibility for taking it forward?
I'm not sure that I understand the question, sorry.
What you just described gives rise in my mind to the apprehension that those who obtained the advice might consider they've fully discharged their obligations because it's with the client, to use that phrase, in another area of the department, and they just get on to the next specific thing that they're looking at.
I think in general that would probably be the case. If you've provided advice, you would assume that Commonwealth officials, who are your colleagues, are actually going to act upon it. If the advice that you've provided has raised legal issues that have got implications for something the policy client is working on, that they would, as professional public servants, be taking that into consideration as well. It might be the case if one of the internal lawyers was concerned that that one of their clients wasn't acting on their advice or was acting in a way that was contrary to their advice, that they would escalate to, in the time that I was there, the Band 2 equivalent of Chief Counsel. And from time to time there are issues where there was robust disagreement on the interaction between law and policy, between policy owners and legal service advisors within the department, that would get escalated for resolution.
And what would that resolution look like? At what level would that take place?
Well, it would probably usually involve somebody at my level speaking to the counterpart in the policy area at my level, and if necessary, it being collectively escalated to deputies.
Right.
So it went up a funnel.
What about responsibility for getting the advice finalised? Whose is that? I mean, it's been delivered to policy. There don't seem to be any more questions to be asked. Who's responsible for asking the external provider to?
It would ordinarily be the legal service advisor who would ask for the advice to be finalised, and I would expect that they would do that in the ordinary course.
Again, subject to any persuasion by the policy area that engaged them in the process.
Or their instructions, yeah.
That is their instructions, yes. If I might have one moment. The final topic, Ms Richards, relates to your involvement with Ms Musolino in respect of an investigation undertaken by the Information Commissioner arising from a complaint about the release of personal details by DHS,
yes,
the Minister's Office. Mm-hmm. You've addressed this in your statement, but what role did you consider that DSS had in respect of the complaint, given that the release of the information was through the Minister's Office at the Department of Human Services?
Well, I thought DSS's role at the time was very limited. The release of information had already occurred. It was an operational matter to the extent that DHS had satisfied themselves in accordance with the Social Security law and the privacy principles that the information could be released. They appeared to have given that advice to the Minister before the complaint was made. And I've tried to address in my statement that was a very limited context within which Department of Human Services Chief Counsel raised it with myself, was the fact that legal advice had been obtained by the Office of the Information Commissioner that went to the interpretation of the protected information provisions of the Social Security law. And in doing so, they hadn't complied with the obligation under the Legal Services Direction to consult with the department who administered that legislation. So that was the Department of Social Services.
You might have reached a different view about it?
About releasing the Information Commissioner, or?
Oh, the legal advice on the question of what information could be released.
The issue that arose for us, Commissioner, was that advice had been obtained jointly by the Department of Human Services and the Department of Social Services, I think in about 2004 or 2005. I'm a fairly eminent lawyer in the Australian Government solicitor on the scope of the protected information provisions. And so the Department of Human Services and Social Services had operationalised that advice. So for some time, both departments had operated on the consistent basis that the law should be interpreted in a particular way.
Right, and then?
And then the Information Commissioner commissioned an opinion from Hennessy SC, who was not familiar or wasn't made aware in that case of the pre-existing advice.
Oh, I see. Mm-hmm.
And so our concern was very much having an inconsistent opinion produced, having potentially quite significant operational implications for the administration of the Social Security law. Because Mr Hennessy's opinion was that the provisions needed to be interpreted in a way that was more confined than the advice that had previously been provided by the AGS.
Right.
That kind of issue is intended to be resolved under the Legal Services Directions by ensuring that if one emanation of the Commonwealth or part of the Commonwealth wants to get an opinion on advice or legislation administered by another part of the Commonwealth, unless it's an issue that's about a existing established interpretation of existing law, that they would consult with the agency that administered.
To make sure they're agreed on the instructions to be given and the...
Well, on the question that might be asked, and also to make sure that in posing that question, if the Privacy Commissioner decided to continue to seek the external advice at that time, that Council would have been made aware of the earlier opinions that existed. Mm-hmm. There are multiple policy reasons to ensure that the Commonwealth as a single legal entity operates consistently. Mm-hmm. It also, if it operates effectively, should reduce external legal service expenditure in circumstances where it might not be necessary for advice to be commissioned.
So did that happen then? Did DHS and DSS work together to agree on the questions to be asked and engage with the Information Commissioner about the obtaining of a further advice which would provide an update more than 10 years after the 2004-2005 advice and take into account legislative changes which had occurred over that time?
I'm sorry, we didn't commission further advice in 2017, I think, when this issue arose. What we were trying to determine was whether or not the Information Commissioner or the Privacy Commissioner had indicated that they were proposing to publish a statement on their website to the effect that the protected information provisions should be interpreted in a particular way. Because that was inconsistent with the advice we'd have earlier obtained and inconsistent with the policy position and legal position that the departments had jointly been following for some period of time, there was a concern about, what would be the correct interpretation? And as you can see from the attachments to my statement, we were proposing that if that couldn't be resolved with the Privacy Commissioner, that we would seek the intervention of the Attorney-General's Department to have that issue of law clarified, perhaps by reference to the Solicitor-General.
Yes, but the resolution of the issue is not for everyone, as I understand it, to engage in the context of a conflicting opinion and seek a fresh advice. It is that the Information Commissioner withdraws the proposed publication based on the advice he's obtained?
Well, we were certainly concerned about the Information Commissioner publishing an opinion or review about the scope of the protected information provisions that we didn't necessarily think was correct.
Yes.
And that we certainly didn't think was consistent with advice that had previously been obtained and acted upon for some time.
But doesn't that highlight the need to then take the next step? That the resolution is not that you convince the Privacy Commissioner to not go there. It is that you say the way this should have been done is, as you just indicated, with a single voice, a single set of questions, because now you have conflicting advices. And the resolution is not to ignore the latter one, but is to take the next step and engage with the process in that context and obtain a new advice according to what you say was the spirit of the legal services directions.
Well, I don't think that we thought it was necessary to seek further legal advice to clarify the potentially conflicting legal advice, because we actually thought that the opinion that had been provided in 2004, 2005 from a very eminent lawyer within AGS was the correct one.
Was Mr Hennessy SC not sufficiently eminent for the department's position?
Well, I had no beef personally with Mr Hennessy SC. I don't think we did, but we just weren't comfortable, weren't satisfied that his view was correct.
But yes, what I'm suggesting is you might come to a different view and you might firmly hold that view and you might be convinced you are correct. But the fact that there is an existing advice already obtained by another entity within the Commonwealth surely highlights the fact that the resolution is not just to repress the inconsistent advice, however much you believe it to be wrong, but to take the next step, because taking only the first step gives the appearance that both departments are working together to impose a position upon the Information Commissioner which requires him to withdraw a process he's engaged in and submit to an earlier advice because the department's asserted is the correct one. You appreciate the perception issue?
There are a number of parts to that question that it's not very straightforward to follow, but I think you're suggesting that there's something inappropriate in the Department of Social Services and the Department of Human Services working together to clarify interpretation of a provision of the Social Security law.
No, I'm suggesting...
I'd suggest that would be the absolutely appropriate thing for them both to be doing.
But in the circumstances where the Information Commissioner has obtained an advice where they disagree with, the appropriate thing I suggest is to engage the Information Commissioner also as the third party to the approach to legal advice under the legal services directions.
Well, and as I have indicated in my statement, we did engage with both the Attorney General's Department in terms of the obligations under the legal services directions on consultation, and with the Office of the Information Commissioner, Privacy Commissioner, about the legal advice that they'd obtained and the concerns that we had about it.
Yes.
And to the extent that if they felt that it was necessary to pursue this interpretation, as we proposed and as indicated in my statement, we were prepared to have that the two opinions put in front of Senior Counsel in a process that was administered by the Attorney General's Department for that conflict to be resolved. In the end, the Information Commissioner actually revoked the decision and that became unnecessary. But that was actually the proposal that we had put forward.
What I'm suggesting is the horse had bolted, the inconsistent advice had been obtained, the Commonwealth has inconsistent advice. What the legal services directions contemplate is the next step.
Well, the process that the legal services directions contemplated would have been that engagement would have occurred before Mr Hennessy's advice was obtained.
Which is why I say
prevent this issue from arising. Yeah. Otherwise, you could end up in a circle of perpetually needing to get advice to clarify advice.
It was less than ideal, but it had happened.
Yep.
And I suggest the appropriate resolution of the issue, because we all now know what Mr Hennessy said, is for the Commonwealth to update its historical advice.
I don't think that we thought that was the case. Yeah.
Can I just ask you about AAT cases? The standing directions require that if there's an AAT Tier 1 case involving, I'm paraphrasing, question of law, a significant question of policy, or a matter of significant media controversy, there's at least those three, it be referred to DSS to consider an appeal.
Yes, there was a process to that effect.
Right, and Robodebt seemed to tick all those boxes. Who was overseeing things from the DSS end to make sure that things were appropriately referred for appeal?
So again, it would have been the team of social security lawyers in what was at one point the public law branch, or subsequently the legal services branch.
But who knew what was going on at first instance, and how was any monitoring done? Do you know the answer to that?
What do you mean at first instance, Commissioner?
Well, the AAT Tier 1 cases aren't published.
So when you say AAT Tier 1, do you mean the Social Security Appeals Tribunal as it would have been then?
I don't think it was then, not by 2017. But anyway, what had been Social Security Appeals Tribunal?
So during my time, it was the SSAT, then the AAT.
Sure, but you get the picture.
I do, thank you. I just want to clarify what you meant, though.
Yeah, but I'm talking Tier 1, but it doesn't really matter if it's SSAT. What's the process from DSS's end to make sure that things are appropriately referred for appeal? Or do you just trust DHS?
Well, I think for the most part, Commissioner, again, DHS were professional public servants, and we relied upon them to identify decisions that needed to be looked at from the perspective of those issues, legal, significant policy or significant media. There was a very large number of decisions that were being made by DHS on an annual basis and being dealt with at the SSAT Tier 1 equivalent stage, and as you say, those decisions weren't published.
Okay, so there's not really any way that DSS exercises oversight to make sure that DHS is making appropriate referrals, is the answer?
Not that I can recall what that process might have been, Commissioner, but that's not to suggest that there was nothing.
And the other part of this question is, did the topic ever come up with Ms Mussolino in your meetings about what was happening in the AAT in relation particularly to Robodebt cases?
Not that I can recall, Commissioner. As I said, we met, it was fairly informal on a monthly basis, and talked about, and could have been a number of issues.
Would the Ombudsman come up as a topic in early 2017?
As I said, I can't recall. I couldn't find any records of those conversations. They weren't minuted. But it wasn't something that when I received the notice from the Commission that I thought, oh yes, I remember all of those discussions. It wasn't something that was really front of mind for me, particularly the Ombudsman's investigation at that time, no.
Anything, Ms Hogan-Doran?
You want, Commissioner, just one moment if I may. Nothing arising. Thank you, Commissioner.
Mr Gregory, do you want Ms Richards excused?
I do. Thank you, Commissioner.
Thanks, Ms Richards. You're excused. In fact, I think we're all going home now. We will adjourn till 10 o'clock tomorrow. Thank you.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.